WBC 4392 of 2022 and contest plus civil 415 of 2022.
Petition allowed. Impugn notification set aside in quest. Contempt case shall be listed separately.
Deeply obliged. Deeply obliged.
May I please, Your Lordship? May I pray for listing of a motion matter, Your Lordship, tomorrow, Your Lordship? This is a
Tomorrow is
matter,
hearing day.
Lordship.
Is there any urgency?
Lordship, urgency in the sense, Your Lordship, this was an employee of a, Your Lordship, Education Department, Your Lordship. Pension order and the so by the Commissioner, Your Lordship, that we have put silence since
Friday.
Friday,
Not
Your Lordship,
tomorrow.
I will not be available.
Anyone can appear.
Lordship.
Anyone can appear.
Lordship.
Please, Lord. My lord, students of my lord, LLB third semester and ninth semester, my lord. They have been declared, my lord, as non-collegiate and they are deferring from the and to appear examinations, my lord. It will to be held on, my lord, 6th of December, my lord. Tomorrow, my lord.
6th of December.
My lord, on Saturday, my lord.
Saturday. Friday we will take it up.
My lord, tomorrow, my lord.
Friday, tomorrow hearing day. Friday.
May please. Lordship, I beg to mention for listing on admission matters. May I pick next week any date for you? No, my lord.
After vacation?
Mountain school has been shifted, my lord. So our children is suffering, depriving from education, my lord.
After vacation? First week of January?
Lord, may I pray on my lord 16, 17 of December? 16.
16, 17 not possible. Thereafter, the last week will be declared as a motion day.
First week, January dates. After 5th, 7th.
With the consent of the petitioner, I think number 20. Petitioner is here.
Item number 20.
20.
Mr. Tobilder, learned serving counsel for Higher Education Department with consent from the other side. Press for listening the matter after 3 weeks.
After 3 weeks.
Fair allowed. Yes, Mr. Bhattacharya.
Two petitions that were filed on 18th of November has not yet been listed. That's regarding an university, recognition to the university on 18th of February. Sorry, November. 2 days. When is obliged.
Yes.
There is an order dated by the 22nd of October, my lord, to list this matter after 3 weeks, madam. So, my lord, may I pray for any day in the next week? Agency that my lord, the private respondent by my lord, by fake data, my lord, she got her service provisionalized, my lord, in my place, my lord. What has, my lord, in fact, earlier advocate has appeared in this case, my lord, as on behalf of the private respondent, and she has chosen not to appear, my lord, further in this case, my lord. So accordingly, court has issued again notice to my lord, the respondent number 5. Direction to release this matter.
Okay, after vacation, in the first week of January.
My lord,
First week of January.
well, in fact, it's a 22 better one, and court has, my lord, taking into account the matters regarding provisionalization of the private respondent. Got the house service.
At what stage the case is pending now?
My lord, that is for admission, man.
Admission.
Yes, man.
After vacation. After
First week of January.
first week of January. Yes.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 24, Lordship. In this case, some instruction is required, Lordship. So kindly it may be fixed after vacation.
Mr.
PK Basu.
P.K. Basu, learned counsel for the petitioner with consent from the other side. Press for listing the matter after vacation. Fair allowed. Yes, Mr. Sharma.
This was mentioned on Monday, it was allowed for listing today. Yesterday it also has been numbered, unfortunately, it has not been listed. Instead of civil bench 2, it has been wrongly registered as civil bench according to medical student for the PG counseling of NEET 2025.
Friday,
Actually, the first round results are already out.
Friday.
Made,
Right.
made legal lordship. Lordship, I beg to mention for listing of a matter for motion lordship. Some urgency is there, lordship may taken up Friday lordship. Matter,
Friday, okay,
lordship, some urgency is there, lordship.
Monday, next Monday.
Maybe it's not, in item 21, the BDC has filed an additional affidavit today, saying for BDC, kindly call for an additional affidavit function.
No, please, your lordship, I beg to mention item number 22, lordship.
20?
32. Lordship may allow me to withdraw it because the department has already issued termination order and we have already challenged the termination order, lordship, wherein notice has already been issued.
You're
This-
challenging the
Yes,
termination.
this
order.
matter is regarding suspension.
Okay, Mr. Arbora, learned counsel for the petitioner submits that he has the instruction to withdraw this petition. Here is allowed. WPC number so and so stands dispose of on withdrawal.
Lordship. Obliged, lordship.
Motion item number 12. It is a motion item. We have obtained certain instruction from our clients regarding the. The matter may kindly be fixed up for 1 week or so.
After 1 week.
1 week or so.
Mr. Your name, please?
US border.
US Bora, learned counsel for the petitioner. With consent from the other side, principal listing the matter after a week.
It may kindly fix though.
Fair allowed, recess and list the matter on.
Ninth.
Right. Yes,
It's a motion.
after 1 week. Yes,
Lordship, I beg to mention, WBC for order, matter related to minimum scale of pay. This matter time only 1 and 2 minutes, so Lordship, please list the matter before vacation.
when do you want?
Lordship,
When do you want?
uh, before vacation, as per your convenience,
Before vacation may not be possible.
after vacation.
First week of January.
Lordship, I have seen another pair, WBC for admission.
Admission. Okay, first week of January. Yes,
Maybe your lordship, lordship with regard to, lordship, a matter for listing your lordship, matter, lordship is a 2019 matter, your lordship. And some of the petitioners are going to be retired, your
when do you want?
lordship, can it be possible? This week is not possible, lordship, maybe before vacation, lordship, it is not. Lordship.
When?
16th, your lordship. Not being convenient, otherwise, lordship. So bless God.
Yes,
May I please, Lordship, I beg to mention for listing, Lordship, for orders column, Lordship, any date, Lordship.
next week.
On 12.
Yes,
Maybe little lordship.
after vacation.
Because first week of pension.
Pardon?
Pension.
10th
Pension.
January.
Pension. Last week of lordship 19 September.
January first week.
I just promotion, I think about 1.
This content petition is non-compliance of the order dated 20 to 2025, that is annexure 1, page 9 to 26. The list, and this order was passed according petition, my, this is a linked case, my lord. The petitioner name, petitioner case was in page number, page numbers, link is 6202/2024, page number 18. The
Okay, let notice go at this, sisters.
yes.
Heard Mrs. A. Buzor Bora, learned counsel for the petitioner. This petition under Article 215 of the Constitution of India, read with Section 12 of the Contempt of Court Act, and the rule framed thereunder is prepared by the petitioner for non-compliance of the order dated 28/3/2025 passed in WPC number 6202 of 2024 passed by this court. peruse the petition and the documents plus and record and also peruse the order dated 28/3/2025. Issue notice to the contemner returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today's. List the matter after 4 weeks.
Item two.
Made please, your lordship. Lord, for violation of order of the honorable, your lordship, they turn to page. So, my lord, it is regarding closure of Udice Court, my lord, and ultimately lordship was pleased to page 12, my lord, from bottom, my lord, second paragraph. In the interim,
Is it not state till
my
now?
lord, hereby communicated that a debtor shall remain state. Now, your lordship would be pleased to turn to page 14. So, my lord, on 10/11/2025, I have communicated the order, my lord. That is the forwarding, my lord. Now, your lordship will turn to Annexer 3, page 17, my lord. I am aggrieved by this, my lord. Your lordship will turn to page 18. The authority did, my lord. I am just mentioning, Lord, current schooling data. Current schooling data, your lordship got it, my lord. Bottom in the middle. Current schooling data. Details. Page 18. 10th line, my lord. Page 18. Current schooling data. Tell.
Okay, let notice go at this.
Yes, my lord.
Heard Mr. MSec Learned Counsel for the petition. This petition under section 11 and 12 of the Contempt of Court Act 1971 as read Article 215 of the Constitution of India is preferred by the petitioner for willful and deliberate violation of the order dated 31/10/2025 passed by this court in WPC number 6104 of 2025. Peruse the petition and the documents placed on record and also peruse the order dated 31/10/2025 passed by this court in WPC number 6104 of 2025. Let notice be issued to the contemner returnable in 4 weeks that be taken by registered force with AD and also by usual process within a week from today. List of 4 weeks.
Oblige, lordship.
Three.
Non-compliance of the order dated 16/7/2025. Relevant portion paid, page 42, page.
Heard Mr. S.K. Goswami, Learned Counsel for the petition. This petition under section 11 and 12 of the Contempt of Court Act 1971, read with Article 215 of the Constitution of India, is preferred by the petitioner for non-compliance of the judgment and order dated 16/7/2025 passed by this court in WPC number 6435 of 2017. Peruse the petition and the documents placed on record and also peruse the judgment and order dated 16/7/2025. Let notice be issued to the contemner returnable in 4 weeks Step be taken by registered post with AD and also by usual process within a week from today. Whatever is available, you do it. But this contender number 1, he has already retired.
Lordship.
Returnable in 4 weeks. List after 4 weeks. But new present incumbent has to be implemented.
Because it is order is of 2025, order that has been sent in. And the person returned 3 years back.
Online, we have seen his name. That is why we have printed.
Not 9.
Okay.
Item 4.
Lordship, this is the contempt petition against Lordship's order. Lordship will find the operating portion at page 20, my lord. Para 11, my lord. The respondent authorities by a mandamus of this court are directed to appoint the petitioners of 20, Lordship. This is the Lordship's order.
Heard Mr. Borua, learned counsel for the person. This petition under section 11 and 12 of the Contempt of Court Act 1971. Read with Article 215 of the Constitution of India. And under Rule 9 of the Contempt of Court, Rule 1977, is initiated by the petitioner, namely Shyamol Krishna Roy and Srimati Kohinoor Barbhaiya, for violation of the order dated 11/9/2025 passed by this court in WPC number 2665 of 2025. Peruse the petition and the documents placed on record, and also peruse the order dated 11/9/2025. Let notice be issued to the respondent, to the contender, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
Item 5.
May it please your Lordship. Lordship, here the petitioner, who is a head teacher, he was arrested in connection with Puria case number 181 of 3 on 13/10/2023. Thereafter, my lord, he was placed under suspension, which is at page, my lord, 28, annexure 7. Annexure 7, page 28.
So what is the subsequent development?
My lord, on the last occasion, the petitioner informed me that there is a chance to revoke the suspension order, but till today, there no order has been passed. So I have to address this court, my lord. And moreover, my lord, this suspension order was issued on 20/10/2023. Until today, my lord, as per my instruction, the review has not been done. My lord, the
When it was passed?
my lord, the 20th of October 2023, annexure 7, page 28.
23.
23, my lord. And lordship may kindly peruse the next order, by which your lordship granted bail to the petitioner. That order was communicated and he was granted the subsistence allowance, which is at page, my lord, 32, annexure 9.
Since then, your order has not been reviewed.
Has not been reviewed. And my lord,
But,
surprisingly, my lord, lordship
no,
may
no.
kindly peruse page 33, annexure
Mr.
10.
Hassan,
My
the
lord.
question is, after grant of bail to you,
My lord.
whether you have reported the matter to the authority?
Yes, my lord.
When?
My lord, after communication of this bail order, my lord, lordship may kindly see the page 32. They have granted the subsistence allowance.
Hmm. No, my question is, when did you communicate the bail order to the authority?
That exact date I don't have, my lord, but I have stated in paragraph, my lord.
Did you file any representation?
That was filed, my lord, but the copy of that representation that was not kept by the petitioner, my lord. I have asked to my client, my lord. And I have stated in paragraph number 8, my lord, it was communicated, and after communication, the subsistence allowance has been granted, my lord. So let them take instruction, my lord, whether it was.
In the order granting subsistence allowance, there is no indication that you have reported the
Yes, my
matter
lord, that
to
is
them.
that is not there, my lord.
You obtain a copy? Copy of that letter by which you have communicated the bail order?
Bail order. Or your lordship may direct them to take instruction whether that was reviewed or not, my lord. In my instruction, as per my instruction, my lord, that suspension has not been reviewed, my lord, till today, my lord. And in the meantime, my lord, I will try, my lord, I will submit a copy of the application, my lord.
No, in that case, they will take a stand that the bail order has not been communicated to them.
But my lord, in the
So
case of
therefore, you obtain a copy of that letter by which you have communicated that you have granted bail
my lord.
in the criminal case to the authorities. In the meantime, they will also obtain instruction.
Obtain instruction, my lord. But my lord, that is on record, my lord. I have talked to my
Record,
client,
it
my lord.
is your statement only
My
in
lord.
your petition, not supported by any document.
Yes, my lord, yes. He has not kept the Xerox copy of this application, my lord.
Heard Mr. Hassan, learned counsel for the petitioner. In this petition under Article 226 of the Constitution of India, the petitioner has rightful setting aside the suspension order bearing number ECA-50/2023/4 dated 20th-10/2023 issued by the Director Elementary Education Assam, and also for issuing direction to the respondent authorities to reinstate the petitioner in service, and also to regularize the suspension period by treating the same as on duty. Mr. Hassan, learned counsel for the petitioner, submits that having placed the petitioner under suspension by order dated 20th-10/2023, the same has not yet been reviewed by the respondent authority. Further, Mr. Hassan, drawing the attention of this court to the order dated 7/11/2023, passed by this court in bail application number 3716 of 2023, submits that by aforementioned order, the petitioner was granted bail by this court, and thereafter the order has been communicated by the petitioner to the respondent authorities by filing one representation, and thereafter by letter dated 2/2/2024, the petitioner was granted subsistence allowance. But till that, the suspension order has neither been revoked nor been reviewed by the respondent authority. And being aggrieved, the petitioner approached this court by filing the present petition. Where is the petition and the documents placed on record? Let notice be issued to the respondent returnable in 4 weeks. Step B, COVID. Fix it at COVID. First week of January.
On 21st January.
Sorted. First week of January.
9 January.
9th of January, step be taken by registered post with AD and also by yourself. You are representing
One,
all the respondent,
except two, my lord, I am,
All, man.
all.
except two.
However, no formal notice is required to be issued since all the respondents are represented by their engaged counsel, by their standing counsel. But extra requisite copy of the petition be furnished to them during the course of the day. In the meantime, Mr. Bora, learned counsel, standing counsel for the respondent number 1, 3, 4, 5, and 6 shall obtain necessary instruction as to whether the suspension order of the petitioner is reviewed or not. And if reviewed, the relevant order shall be placed on record on next date. List doctor, list of
Obliged.
Obliged.
Number?
Jalo. Not this. Compassionate appointment, my lord. My lord, my case has been DLC due to loss of spent of force of my application, my lord. Impugned DLC minus page number 40, my lord. Page number 40, my lord. My name is page number 43.
volume. Page number 14.
43 relevant portion, my lord. Last row, my lord. Serial number 10, my lord. In the right hand side, my lord, PLC resolution.
Okay, madam, you obtain instruction
Balance of service is less than clear.
no. Of the
Balance of service is less than clear.
This is earlier case. Earlier.
Okay, you're not going.
heard, Mr.
FL Oscar, my lord.
Learned counsel for the petitioner. The petitioner is aggrieved for non-consideration of his pair for being appointed on compassionate ground by the district level scrutiny committee, Kasar, in its minutes of meeting held on 30th
16-8, my lord. Page number 40, my lord.
No, last when it was considered. Sixteen eight 25
My lord.
in its meeting held on 16/8/2025. Where is the petition and the documents placed on record? And also where is the minutes of the meeting held on 16 8/2025. And it appears that the DLC has rejected the proposal of the petitioner as it spent its force as per Principle 10 of the OM dated 1/6/2015. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their engaged counsel. Miss Das, you are for respondent number 5. Respondent number 2, Commissioner and Secretary. Miss K. Fokon. 2, 3, and 4. And 1? 1 and 5. No formal notice is required to be issued since since all the respondents are represented by their engaged counsel. However, extra requisite copy of the petition will be furnished to them during the course of the day. List the matter on 19. In the meantime, the respondent authorities may file their affidavit in opposition. Madam, you file your affidavit.
Madam? Madam?
Yes.
Was ESS, my lord. Some allegations, my lord, he has been from service, my lord. And my lord, regarding this, he has filed a appeal petition at. So that has not been disposed of, my lord. So in this petition, at this stage, my limited may be directed to consider my
Mr. Chakraborty, any instruction is available with you?
Nature of this territorial rule. The proceeding was conducted at Jalpaiguri district. He was working in the Jalpaiguri district. So none of the lordship in similar case lordship, they are allowed to withdraw and file the application before the appropriate forum. Appropriate court law. Lordship and this later, the ONGC case is very.
Okay.
There is 6 lordship that. Oh, High Court should entertain words. When there is no territorial jurisdiction, paragraph 12 lordship. It can be this. Paragraph 12 of the Supreme Court judgment. And this is a similar case where this court allowed to withdraw and approve the appropriate. Paragraph 12. Here the work contract has to be executed in Gujarat. Tender by acceptance at Delhi, process at Delhi. The case was filed at Kolkata High Court. Lordship.
Mr. Bora? So the petitioner was posted in Jalpaiguri.
If it. If it.
Page number 146. Yes.
The order was communicated with the petitioner, my lord, and his residential
Address here.
Eleven your body years Madi Madiaka. So my lord, when the order has been communicated to the petitioner at his residence, that the jurisdiction of the court. And initially the petitioner was appointed under the jurisdiction of the Honorable Court at Adela.
Next one, my lord.
It was
Court.
Adela next one, my lord, paid. My lord.
No, that's all right, but
Not at his residence under this honorable court, jurisdiction.
And on that ground, I thought that
Petition is maintainable here, my lord.
so the order has been communicated to the petitioner in his residence under this honorable court.
no, the departmental proceeding was initiated at Jalpaiguri.
Yes, my lord.
And the petitioner was serving there at the relevant point of time.
Yes.
No, merely because the termination order was communicated to him
Yes.
in an address within the jurisdiction of this court, can this court invoke the jurisdiction?
Judgments also, my lord. I will.
Order is communicated to the petitioner after which under the jurisdiction of the High Court. In that High Court, part of that
Can you produce those decisions?
My lord, your lordship may take up some other day. I will produce the judgment.
I have transferred the.
Okay, okay, all right, Monday then.
Judgment is that my lord, when the order is communicated to the petitioner.
Okay, all right, we'll see.
Then comes my lord, it is maintained.
Heard Mr. B.P. Bora, learned counsel for the petitioner, and Mr. Chakraborty, learned DYSGI. CGC.
For all the response.
For all the respondents. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 12/9/2024 passed by the law officer and presiding officer of the General Security Force Court, whereby the petitioner was dismissed from service. The petitioner who was serving with a registration number 998001074 HC within bracket ZD of 40th Battalion BSF from service and confirmed by the additional DG HQRS SDG BSF EC on 12/10/2024. No, 22/10/2024. Mr. Chakraborty, learned counsel, learned CGC, relying upon a decision of Honorable Supreme Court in the case of Oil and Natural Gas Commission versus Utpal Kumar Basu. Reported in 1994, 4 SCC 711 and also two orders passed by two coordinate bench of this court dated 29/8/2025 in WPC number 6723 of 2022 and the order dated 29/10/2024 in WPC number 5124 of 2024 submits that at no point of time the cause of action arose within the jurisdiction of this court, and as such, in view of the observation made by Honorable Supreme Court in the case of ONGC, Supra, especially at paragraph number 12, this petition is liable to be dismissed. At this assess, Mr. Bora, learned counsel for the petitioner, submits that the the dismissal order of the petitioner was communicated to the petitioner at the address which is located within the jurisdiction of this court, and as such, part of the cause of action arose within the jurisdiction of this court, and as such, this court has territorial jurisdiction to adjudicate the present writ petition. And Mr. Bora further submits that he may be granted some time to produce relevant decision of Honorable Supreme Court on this point. There is accordingly allowed recessal is the matter on Monday.
Yes, my lord. Obliged, my lord.
Matter number
May I please, your lordship? Here, your lordship, the petitioner has put to challenge an office memorandum, your lordship, dated 22/5/2025, your lordship, which was based on a UGC public notice, your lordship. Probably, your lordship, two other petitions or challenging the same notification are presently pending before this honorable court, your lordship. Let your lordship, since already notice has been issued in those cases, your lordship, let this case also, your lordship, be tagged with those cases, your lordship. My case is this, your lordship.
No, so do you issue notice at this, is that?
Lordship may issue notice, your lordship. We don't have any interim prayer. The very foundation of the office memorandum, your lordship, has the UGC public notice that has been set aside and quashed by the Delhi High Court, your lordship, saying that it is without jurisdiction, your lordship.
Okay.
Thereafter also, your lordship, they are insisting on, your lordship, the same office memorandum, your lordship. That is precisely the case, your lordship.
Heard Mr. S. Barthapur, learned counsel for the petitioner. Mr. S. Das, learned standing counsel for the respondent in Higher Education Department. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the office memorandum struck executive order bearing OM number 65298 struck 2025 struck 2 dated 22nd of May 2025 issued by the Secretary to the Government of Assam Higher Education Department, and other consequential actions struck decisions taken pursuant thereto, and also issue direction to the respondent authorities not to give effect of the said office memorandum. Mr. Barthakur, learned counsel for the petitioner, submits that the said OM dated 22/5/2025 is being challenged in some other writ petitions, being WPC number 4001 of 2025. And as such, after issuing notice in this petition, the same may be tagged with the aforementioned writ petition being WPC number 4001 of 2025. Accordingly, after hearing learned counsel for both the parties, it is provided that notice be issued to the respondents returnable in 4 weeks, step be taken by, no, for no formal notice is required to be issued since Mr. Das. No, UGC is there. Somewhat, okay. How about no formal notices required to be issued to respondent number 1, 2, 3, and 4? Since Mr. Das entered appearance and received notice, however, extra requisite copy of the petition be furnished to him during the course of the day. But you have to take step upon respondent number 5 UGC. But no one is appearing before this court. Step be taken upon respondent number 5 by registered post with AD and also by usual process within a week from today. List of top 4x. Register shall take this writ petition along with WPC number 4001 of 2025.
Item number 9.
We'll find it page 61 through 61, madam. Approach.
Page number?
Page number 261, it starts, the order starts from page 263, madam. So order part starts from page 60, madam.
So you want a similar order to be passed in the present case also? Yes, have you gone through it?
Each should file separate representation, your lordship, and after verification of the documents, your lordship. This order should be flat, your lordship. That much, your lordship.
Separate representation.
Yes, sir. Yeah.
How many petitioners are here? 8 petitioners.
Lordship, page 67, paragraph 8, like on such representation being filed by the present petitioners, the respondent of the case shall examine and consider the right of the decision of the division bench in the case of Abdul Qadir, especially the paragraph number 16 of the same decision, and if the respondent of the case are satisfied that the present petitioners are similarly situated with the petitioner of the petition number 2023, Abdul Mutlib and others, then they shall also take the same benefits of the state of state as granted in the state case. So that much your lordship observation should be reflected.
So do we fix any timeline? Okay.
Your lordship, there is 8 petitioners is there. Your lordship, verification of documents needs some time, your lordship. In the meantime, your lordship, first they have to approach by filing one representation.
Yes,
Then your lordship has
after receiving the representation within a period of 6 weeks. 6 weeks. 6 weeks.
Similar, it's only that the higher department, education higher department.
So here also, here one same order should be passed.
Yes, it's 300 million point.
Okay. Mr. Das, any objection? No. Okay.
Item 11.
Made. Confirmation of their surveys. 2013. Claim is this, my lord. Old pension is. 1996 onwards.
So you have filed a representation to the respondent authorities. At page number?
Your lordship, 105.
One zero five.
Memorandum for inclusion under old pension scheme OPS.
Yes, madam. Mr. Sheikh, if we dispose of the petition by directing the respondent authorities to dispose of your representation, whether it will serve your purpose? Okay, then let notice go at this is.
Whether it is all pension or the pension also. Power and maybe it is okay.
The question arises. Because the argument that accounts will be holding of this accountant general. No, see, the radio has said. He has said, because the money should be disbursed from them.
No, that's all right, but in the event of that GPF account,
It will come for or pension or maybe pension person. That's what they are.
no, Mr. Sheikh, no, Mr. Sheikh, if your pair is only for shifting you from a new pension scheme to old pension scheme, the AG has nothing to do with it.
Only old person.
Or Mr. M.A. Sheikh, learned counsel for the petitioner. Ms. Sutia, learned standing counsel for the respondent in elementary education department. Mr. Talukdar for respondent number 7. Mr. Pegu for respondent number
6.
Respondent number 6. Ms. Borua for respondent number 2. And Ms. Bora for 3 and 8. 1 and 4. 1 and 4, Ms. Sutia. In this petition under Article 226 of the Constitution of India, the petitioner has tried for issuing direction to the respondent authority to provide pension to the petitioner under the pension rule prevailing before 2005, which indicate old pension scheme. Here is the petition and the documents placed on record. Mr. R.K. Talukdar, learned counsel for the respondent, standing counsel for the respondent number 7 submits that in this present petition, no relief is being sought for against the respondent number 7. And as such, respondent number 7 is not a party, not a formal party in this proceeding. And as such, the name of respondent number 7 may be deleted from the array of this petition. The submission of Mr. Talukdar is considered in the light of the pair being made in this writ petition. And it appears that the only pair of the petitioner is to provide pension to them under the pension rule prevailing before 2005, in which the respondent number 7 has no role to play. And in that view of the matter, the respondent number 7 seems to be not a formal party in this proceeding. And accordingly, it is provided that the name of respondent number 7 be deleted from the array of this petition. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued, since all are represented by their standing counsels. But extra requisite copy of the petition will be furnished to them during the course of the day. List the matter after 4 weeks. In view of deleting the name, taking out the name of the respondent number 7 from the array of this petition, Mr. Sheikh, learned counsel for the petitioner, shall file amended cause title within a period of 1 week from today. List after 4 weeks.
Item 13.
Since 1990. My appointment for the 20 resolution.
Where is the impugned order?
Education order
No,
directed.
no, the order passed by the educational tribunal.
There are 8 number of respondents. The government education department, finance department, then SNC, then anything committee, then headmaster, and the private respondent. My lord, one council, government council, has represented all the respondent, thereby, my lord, there is a improper representation by the government advocate, my lord. Sitting, my lord. And the earlier headmaster and the school managing committee has taken their evidence in my favor, my lord. My lord, one, let's one, my lord, page 40. Page 46, this is the certificate issued by the headmaster. Time to the national school, the school got professionalized in the 30. My date of joining was 1994. 1994. By the same headmaster has submitted his testimony. Against 70, page 78. Number 6, 7, and 8. 7 is the headmaster, 6 is the SSC, and 8 is the private headmaster.
Okay, let notice go at this is it. Heard Mr. N. Sharma, learned counsel for the petitioner. Miss P. Das, learned standing counsel for the respondent in secondary education department. 1, 2, 3. Mr. Pegu for 4. Ms. Borua for 5. And school managing committee 6. No, school management committee.
No, it cannot appear, your lordship.
Oh, no. Who constitute a school management committee? By the inspector?
Yeah.
No, school management committee is statutory body constituted by the inspector of school.
President and secretary, they will represent the affected lord. We cannot represent. President and secretary, yes, not the affected lord.
Okay.
Of the firm.
In this petition under Article 226 of the Constitution of India, the petitioner has challenged the judgment dated 26/9/2025 passed by the Educational Tribunal Lakhimpur in title suit within bracket education number 66 of 2019, by which the claim of the petitioner for provincialization of service was dismissed. Perhaps the petition and the documents placed on record, and also perhaps the impugned judgment dated 26/9/2025 passed by the Learned Educational Tribunal Lakhimpur in title suit education number 66 of 2019. Let notice be issued to the respondents returnable in 4 weeks. Step be taken upon respondent number 6, 7, and 8 by registered post with ADN also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1, 2, 3, 4, and 5 since they are represented by their English council. By their standing council. However, extra requisite copy of the petition be furnished to them during the course of the day. List the matter after 4 weeks. In the meantime, registrar shall call for the record of the title suit number so and so so and so from the Learned Educational Tribunal, Lakhimpur. Place the matter after 4 weeks.
My lord,
Pardon?
in the month of March, he is going to retire, my lord. After that, March, maybe given.
No, first you have to serve notice upon the private respondent. Okay, additionally, dusty service is also permitted. After effecting service upon the private respondent, the petitioner shall file an affidavit before this court. This is the matter on
9th January.
9th of January.
Item 14.
Fire pension. More important thing is, financial hardship is going on, lordship.
Mr. Pegu, you obtain instruction while the provisional pension has been stopped and regular pension has not been finalized. Heard, Miss? Learned counsel for the petitioner, and Mr. Pegu, learned standing counsel. Mr. Pegu, you are appearing as government advocate or standing counsel?
Additional senior law.
Additional senior government advocate. Additional senior government advocate. For the respondent number 1, you are for 1, 3, 4, and 5. And Mr. Pegu for respondent number 2. Respondent number 2. Respondent number 2.
Department.
2 and 6.
2 and 6. 2 and 6. In this petition under Article 226 of the Constitution of India, the petitioner has filed for issuing direction to the respondent authorities to release the pension as well as final gratuity to the petitioner, and also to compensate him for delayed finalization of his pension. Ms. Saha, learned counsel for the petitioner, submits that the petitioner was an employee of the Elementary Education Department and retired from service on 31/8/2016. And thereafter, for some period of time, he was granted provisional pension, but the same was stopped. When it was stopped? Provisional pension? July 2025. Then the regular pension has not yet been finalized, and also the gratuity has not yet been paid by the respondent authorities. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their engaged counsel. But extra requisite copy of the petition will be furnished to them during the course of the day. I'll list the matter on
On 21st January.
21st January. In the meantime, Mr. Pegu, learned additional senior government advocate, shall obtain instruction. And also, he will bring on record the same by filing an affidavit in opposition. List accordingly. After 4 weeks.
This is in fact a third round of litigation. And this time, person is challenging is. Original application was not. The wrong date, lordship.
Page number 20,
28, lordship.
28. Serial number
And his date of application is 9/11/2022, lordship. In fact, 2009, lordship. But its original application was not considered, lordship. It's submitted application on 18/12/2009, lordship. And they considered it as his application wrong date, 9/11/22.
where it is mentioned that the deputy commissioner has taken note of the date of application as 9/11/2022.
Is the ask court.
Yes.
Column, lordship. Original application date 18/12/2009.
Heard, Mr.
Yeah, my lord.
Learned counsel for the petitioner.
Date of the petitioner sometime 25. He was a minor lordship. At the court of trial lordship, he was he's correct, but the application is 2009. That also he has 7 weeks, my lord. But he's not the document said that. Fiction of this it should be assigned to the point. He was a minor lordship. Nobody was for minor lordship.
What was his age at the time of the death of his father?
It's also now it's all this thing has been not 32 lordship. He's at 2000 lordship minus 24 specifically related. You can know about 2009, 32 months. That was it, no? Was. No.
11 years.
11 years. No, my lord. 2011. No, 2009 I think that would go up to now to 34. So 2009. 2005 or 2025. 2002 and that time of that is fun.
No, that's all right, but at the relevant point of time, he was minor. Therefore, I am asking you, what was his age at the relevant point of time? No, his father died on 2002. What was his age at that point of time?
He was lordship. 12 years maybe lordship.
Do you
I
have
have to
any
calculate
document to show his age? Do you have enclose any document to support the age of the petitioner?
Have to go through lordship. 2009 lordship, he passed the SSLC exam.
9.
Yes. 1993. 1993 lordship. He completed SSLC examination lordship. Examination lordship, he immediately poured.
Okay. Mr. D. Bhuya, Learned Counsel for the petitioner, Mr. Pegu for Learned Additional Senior Government Advocate for respondent number
1, 2, and 6.
1, 2, and 6. For rest of the respondent? 3, 4, and 5. 3, 4, and 5. The petitioner herein is aggrieved by the order dated 30/12/2022 passed by the Deputy Commissioner Dhemaji, whereby the claim of the petitioner for being appointed on compassionate ground was rejected. The Learned Counsel for the petitioner submits that the father of the petitioner, who was serving as head teacher in Simen Sapore Bodu LP School, Dhemaji, died on harness on 1/6/2002. And at the relevant point of time, the petitioner was minor. And he passed SSLC examination in the year 2009. And he also filed an application on 18/12/2009 for being appointed on compassionate ground to the Deputy Inspector of School, Dhemaji. And the proposal of the petitioner was placed before the Deputy Commissioner Dhemaji, but by the impugn order dated 30/12/2022, the Deputy Commissioner has rejected the proposal of the petitioner, taking a wrong note of the date of filing of the application as 9/12/2022, whereas the petitioner has filed the application on 18/12/2009. And in support of his claim, Mr. Huya has drawn the attention of this court to the application dated 18/12/2009, annexed with the petition as annexure number 1. Under the given facts and circumstances, it is provided that Mr. Pegu, learned additional senior government advocate, shall obtain necessary instruction as to whether the Deputy Commissioner Dhemaji has taken note of the date of application correctly in the impugned order dated 30th/12/2022, and apprise this court on next that lists the matter on 12th December.
Item 16.
Challenging the same speaking order, Lordship. And here also, my lord, original application was not considered, Lordship. Similar issue, Lordship.
Oh, when the original application was filed,
Lordship will find at page 19, Lordship.
19.
19, Lordship.
Eight 2011.
Speaking order dated 30/12/2022.
Date of application
Yes,
is
date of application was wrongly
8/5/2011.
considered. Speaking order, your
Speaking
Lordship will
order
find
is
at page
dated
29.
30th December 2020. Okay, Mr. Pegu, obtain instruction.
17.
This case, really in respect of providing minimum wage. What happened, my lord, in the year, these people were getting rupees 300, then in the year 1999, civil rule. Converted from 300 to 3,500. But incidentally, what happened that 2,500 was provided in the year 2007. As 2,500 only, whereas in respect of all other employees, these wages have increased. Those notifications are also there. This may go, my lord. This case.
Heard Mr. Abedin, learned counsel for the petitioner, Mr. Fokon for all the respondent. 1, 3, 4, 5, and 6. And Ms. Borough for respondent number 2. Respondent number 2. Okay. This petition under Article 226 of the Constitution of India, the petitioner has right for issuing direction to the respondent authorities to regularize the service.
That has not been, my lord, there's no sample. Page 58. There is no sample, see whether it will be received by the. That is the number.
I gave my statement that it has been received.
General practice, my lord, all cases, my lord, the stamp and seal is the requirement, mandatory requirement.
For issuing direction to the respondent authorities to regularize their service. And also to issue direction for payment of salary stroke honorarium at the minimum wage rate of skilled worker, which is presently at the rate of rupees 16,140 rupees. As per the government notification number ECF number 412503 of 03/415 dated 4/4/2025. Mr. Abedin, learned counsel for the petitioner, submits that the petitioner has been working as pre-primary teacher for last 30 years
Schools.
in a provincialized school, and they have been paid a sum of rupees
2,500.
2,500 since the year 2007, being the honorarium being the honorarium.
Based on this honorable.
And the same was done as per direction issued by this court in WPC number.
This CR number, my lord.
CR number
My lord, CR number. 1 minute.
99.
My lord, sorry, my lord. It is the WBC number. 253 of 1999. It is annexure 4.
Further, Mr. Abedin submits that the petitioner has also filed one representation to the respondent authorities on. Where is the representation?
My lord, annexure
On 28th of August 2025, which is enclosed with the petition as annexure number 13. But the same is yet to be disposed of by the respondent authority. Do you obtain any, when did you receive the copy of this petition?
The copy of this petition has been received. It's a
When?
motion matter.
Maybe, but when did you receive it?
Page 58, madam.
I am asking you, when did you receive the copy of the petition? Posiso, when did you receive it? Now means when? Mr. Abedin, when did you serve the notice of this petition? 21/11. No, whether you obtain any instruction from the authorities?
The matter is filed today for the first time.
No, then what is the purpose of serving it in advance? No, please sit down. Please sit down.
Real signature. 20 page 17, I have given the
Last pilot received.
Okay,
Of the
okay.
DD Assam on the same day by receipt number 1041. And the mere statement is possible. Yes, statement on both. Very unfortunate, on both I'm saying. How can I give a number if it is not a number? Let it be your worship.
Okay, taking note of the submission of learned counsel for both the parties, it is provided that at this session, notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their English counsel. But extra requisite copy of the petition will be furnished to them during the course of the day. List the matter after 4 weeks. In the meantime, the respondent authorities shall file their affidavit in opposition. It is being clarified that pendency of the present writ petition would not be a bar for the respondent authorities in disposing of the representation filed by the petitioners dated 22nd of August 2025. List of top 4 weeks.
But it is initially the high second in the end only for 2 years we pick up that. But that's good. Not to.
No, what is your pair in this petition? Hmm. Hmm. So the period is 11/3/2000 and the amount is rupees 1,20,618.
Yes, ma'am.
So this is your pair.
Yes. Notice maybe.
Mr. Soma? No, you obtain instruction.
Yes.
If necessary, we will later on issue notice.
Yes. The prayer is praying for the areas from 11 to 35.
There are representation up to 2024, 2008.
Instruction, we'll take it up on next Wednesday. Heard Mr. D. Gogoi, learned counsel for the petitioner. Ms. N. Kokon, learned standing counsel for the respondent in elementary education department. And Ms. K. Kokon, respondent number 4 and 5. The petitioner is aggrieved for not placing her application for appointment on compassionate ground before the district level committee. Though such application was filed on 11/11/2012. Mr. Gogoi, learned counsel for the petitioner, submits that the father of the petitioner was serving as assistant teacher and he died on harness on 22nd October 2012. Thereafter, the petitioner has filed the application on 11/11/2012 for being appointed on compassionate ground, and the same has not yet been placed before the district level committee. Accordingly, taking note of the submission of learned counsel for the petitioner, it is provided that Ms. Fukon, learned standing counsel for the respondent in elementary education department, shall obtain necessary instruction as to whether the application filed by the petitioner on 11/11/2012 is placed before the district level committee or not, and apprise this court on next Wednesday, 10 December.
Madam, 41.
Right, please, Your Lordship. But I think Your Lordship will have to have 6 minutes to narrate the facts.
Okay.
Because I am coming first to the coordinate bench order which gave me liberty. And number two, my lord, almost similar factum, my lord. Another coordinate bench, my lord, intervened in the disciplinary. My lord, the question is, there is no bar for disciplinary proceeding against a government servant when a criminal trial is on. Both can go. But it has to be an independent disciplinary proceeding, cannot merely bank on the arrest, FIR, and investigating officer's report. I must get the opportunity to cross-examine in the disciplinary proceeding. And at times, there are Supreme Court decisions also that may prejudice my trial. If the disciplinary authority produces the IO and I cross-examine him, that may prejudice my ultimate trial. So this case is decided under this, my lord, pretext, and no exhibits are given before the disciplinary proceeding. I am a, my lord, lady officer, district elementary education officer, 2021 arrested under Prevention of Corruption Act. FIR is at my lord, page 40. I was arrested and naturally I was suspended. Bail was granted, proceeding was initiated, then it is all about the FIR was filed, I was arrested, and as your lordship know, 48 hours detention, my suspension, so I was suspended. Then the department, my lord, because of my arrest in a criminal case, my lord initiated a disciplinary proceeding. The imputation is quoted at page 10. So, I'm not troubling with so much of annexures. Page 10. Of my prediction. While you are serving, page 10. While you are serving at so-and-so, 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 while accepting bribe, so-and-so, 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 you were arrested on the same day in connection with so-and-so, as amended, act of your as lowered credibility of the government and caused embarrassment to the government, which amounts to criminal misconduct. This was the charge. I will not comment on the merit or demerit of the ongoing trial. I'm commenting on the manner the government disciplinary proceeding has been handled, my lord. Because it is a case, my lord. When I am acquitted, everything is gone. When I am, my lord, convicted, my lord, I am out of this school. irrespective of suspension order. This suspension order has been extended and extended and extended. Then what happened? I replied to the show cause notice, which the court with the quoted imputation. And thereafter, my lord, they are reinstated. On 4/6/2001, Lordship may have a look at Annex 5 at page 50. All right, you are reinstated, your trial will go ahead. Page 50. That was June 21. Then thereafter I continued. I was reinstated and posted that continues. Then pardoning, then another issue cropped up. Pertaining to my taking leave, casual leave for 4 days. It was put on and because of that I was put again under suspension. On the day I resigned after the casual leave. The background is like this. Kindly have a look at page 52. I submitted a casual leave application under the normal practice. Page 52, dated 29/2003, it was addressed to the Deputy Commissioner, petition for CL along with permission for leaving. So for 5 days, I prayed. Below your see the hand and seal of the office of the Deputy Commissioner, meaning thereby that my leave application was received by them. Next page, your lordship will see 19, 2 days before. From 21 to 28, 5 days sought for leave, 2 days before. Here also below a seal, it is communicated to the my copy to the Director Elementary Education and seal is there. So I apply. And here also in page 53, I said that during my period of absence, so and so of the Office of Inspector of Schools will act as in charge to look after the normal fund. Then I send a WhatsApp. Under normal practice, the Deputy Commissioner not essentially gives me a reply next day that all right, I am sanctioning your leave. But it is reflected that the leave was sanctioned, which your lordship will find at page 55. It was by the Deputy Commissioner himself. Passes to imagine so and so. There was talent search examination. That went on. That was not disturbed because of my absence only. December, and in view of the leave of Inspector of School, so and so, Sri so and so is entrusted to look after the affairs of the inspectors. Meaning thereby that I was on leave, and therefore somebody else of the office was entrusted with the job. This letter set in place that my CA was accepted. I was allowed to go on CA. Then what happened? Because of this, my lord, another disciplinary proceeding was initiated with respect to under suspension by page 58. Again,
Page number?
58. Your lordship, this was by the secretary. Your lordship, second, third paragraph. Third paragraph, slightly middle. See the allegation. Srimati Jyotsna Rani Burman neither applied. The allegation is that I neither applied for leave nor intimated to the I took these earlier 2 documents. It was acknowledged by them. The Deputy Commissioner said that in my leave period for 4 days or 5 days, this man will be working. So the allegation has no foot. Then again, in view of above, next paragraph, so Inspector of School is hereby placed under suspension. I filed an appeal against this particular suspension order, and my lord, that appeal, I not to the to your lordship to that appeal. When that appeal, nothing was done, then I approached this court. I approached your lordship, challenging this suspension with regard to my lord casual leave. So far as the trial is concerned, ongoing trial, I was already reinstated. Trial will take its place, it will take its own course under the law, my lord. I am nobody to comment. Page 62 to 67 is the order, my lord. Page 63. Lordship may straight will come to page 64. Impugn order, however, does not indicate reasons as to why he is suspended from the post of PO Bongaigaon. Only reflects petitioner's absence from her office. Inspector further submitted that an appeal was preferred. State appeal stated to be pending. Then below, having heard learned counsel, it is seen that there is an appeal filed. Learned standing counsel department also doesn't have any instructions from department to the status of the appeal. Then Lordship may come to page 66. Considering page 66, considering the petitioner has been placed under suspension statutory appeal pending, this court is of the view there will be no bar for the secretary government to and dispose of the appeal applying doctrine of necessity. There is presently no higher authority above secretary. Given 2 weeks time on receipt of certified copy to pass a speaking order and therefore serve a copy. If any details are found to be necessary while deciding, secretary shall call from the petitioner and requisition from any other departmental authority. Next, as it is also submitted learned appeal for the petitioner by Korigandan, certain so and so, a copy thereof could be procured only after filing the petition, although Korigandan has been issued. It is directed that the same shall not be considered to be a bar, and the entire matter and concerned to hear entire matter and say speaking order as directed within the time frame. Accordingly, the petition disposed of in terms of the above. It is needless to say that petitioner given liberty to approach this court if her grievance are found to have not been redressed by the authority concerned, even after disposal of the. Therefore, my lord, with this liberty, I am here before your lordship because they have done nothing. Again, before your lordship. Then, this bill was later on perfectly rejected. After all this, my lord, the so-called notice was, which was given to me, page 69, my lord, reference page 69, my lord. This is the charge sheet given to me about the leave with the statement of allegations, right? This, again, about the leave. Applied to that. Now, page 75, the inquiry report came. Inquiry officer also reiterated the findings. Neither applied leave, page 80, below. Below, findings 1, 2. From the statement, it is made apparent that Srimati Borman neither applied for leave nor intimated the same. That I never applied for leave. This is also the findings. Submitted leave application. Then, my lord, what happened? Lordship may kindly turn to page 91 order. This is a peculiar order. It marks question. Second, third paragraph. Here they have merged unprecedented. That under what circumstances? This is an order by the secretary questioning the deputy inquiry officer, asking him for further particulars. Where is leave so and so. It is also not clear to the committee that under what circumstances the deputy commissioner was not apprised in respect of leave petition. Inquiry report is not clear as to what all the IAS, concerned IAS were made aware. Next paragraph. Where is the considering name so and so, so and so, so and so? The disciplinary authority has decided that the entire matter requires further clarity from IO and authorities involved in the entire process. So the secretary's observation was there. But you inquiry officer, your report is not clear. That she never submitted CL application and all these things. Then your lordship may come to page 106. This is peculiar action on part of the comment. So far as this. This is 125. 1, 2, 3, 4. This is an order extending my suspension, but kindly see, my continued suspension by initiation of this proceeding is under challenge. Whereas considering the grave nature of the charge committed as of the inquiry submitted, so and so, so and so, so and so has left headquarters without a process normally. This is about leave. Then the next is about the whether so and so court rendered accepting department proceeding is a matter of final step in the process. So how can you class two independent proceedings and pass a common order? One is a disciplinary proceeding pertaining to casually, and one is your search during because of my arrest in connection with the Prevention of Corruption Act. How can you take both for construction, for continuation of suspension and take action? Here, my lord, I will place a distance of the coordinate bands. Listen, kindly have a look at this. Here was an excise commissioner. He was arrested in a POSCO case. POSCO. Then arrested, suspended. Then a departmental proceeding was conducted. Simply the investigating officer was called and he produces the charge sheet before the disciplinary authority and it was reproduced and the inquiry findings was given as guilty. I am afraid I'll have to read. Writ petitioner has been filed by a petitioner who is employee deputy superintendent of excise. Petitioner was taken into custody for more than 40 subsequently, go so and so. Petitioner was also placed under second. Paragraph 3. Submits that pursuant to investigation pursuant to FIR law, charge was filed, matter presently trial, department proceeded with departmental inquiry officer concluded the inquiry. That apart, suspension of petitioner has not been reviewed as required under so and so. Council referred to the judgment of Paul on this case. That is a famous case, my lord, I will rely if necessary. That where there is bar for simultaneous continuation of disciplinary proceeding and criminal trial, however, where both of the disciplinary proceeding and criminal trial based on same and similar charges, it is advisable to state in a proceeding till conclusion of the criminal proceeding. Submits that the writ petitioner has been filed challenging disciplinary proceedings. So that's my submission, my lord. Then paragraph 7. You should notice till the next returnable date, the disciplinary authority in the department of Government of Assam will not proceed to pass any final order on the inquiry report, which is submitted by the inquiry officer. So therefore, my lord, my prayer is, I am still more than 2 years suspension. No coercive action, my lord, with regard to the disciplinary proceeding. That is my prayer. And then let them file a response. I am coming with the liberty given by the earlier coordinate bench. I have shown it to the process.
Yes.
We cannot do both. I must be allowed to cross examine. You can, trial can go on, and your disciplinary proceeding can go on. But I must be able to, I must be given opportunity to cross examine the complainant. You cannot. May I be relying on my lord the charge sheet of that case or
At what is this, the disciplinary proceeding is pending now,
the inquiry report has been
given.
given and short anytime, my lord, something may happen.
No, whether the copy of the inquiry report was furnished to you,
Yes, furnished,
you have submitted your reply.
furnished. I have submitted my reply.
Okay.
Now it is pending. Tomorrow they may dismiss me. Like the other excess commissioner's case. Excess appointment case. Trial, you know, once I am convicted, I am out of this court. But what if I am acquitted? So this is not the way to punish a man by way of a disciplinary proceeding. Even though there is a trial pending against me. And I am defending the trial. I will not comment on the trial. I shouldn't. So the other whereby the
So that Paul Anthony's decision is with you? Furnish a
Yes.
copy.
Paul Anthony is my lord. Lordship may reserve the order. Paul Anthony's case I am citing 1999 volume 3. No, 1999 volume 3. Yes, I am giving two decisions. SCC 679. It Paul Anthony, it will display. It will display 99. Well, dear, my lordship will have a look at page paragraph 22. Paragraph 20. It is the settled law now. The department proceeding in a criminal case and proceed simultaneously as there is no bar. Yes. If the proceeding criminal case are based on identical and similar facts, employees of a great nature involved complicated questions should be able to state the departmental proceeding till the conclusion of the trial. Where's this matter? That's a very copy. So that's all. While it will take its own course, my lord, I am nobody to comment. But double jeopardy.
Yes, Mr. Sharma, what is your stand?
It has also armed provided. Fine. Meanwhile, don't take any further action on the disciplinary proceeding. I am suspended. I am getting 75. Periodically, they are extending my suspension.
Okay, we will pass the order.
Lord, obliged, Lord. Much obliged.
Item 42.
In this case, my lord, I have challenged the order dated 21/8/2025, my lord, passed by the my lord, the Assam, wherein the my lord, private resolution number 4 has been given the charge of in charge headmaster, my lord, of Motisor High School in the district of Dhubri. That is page 26, my lord. After inquiry, my lord, I came to learn that my lord, he obtained the BEd degree in 2011. That is page 27 from my lord Goregaon BEd College. And my lord, page 28, it is the program of the BEd examination of 2011, my lord. And it shows that, my lord, the examination was held from August 3 to September 14 of 2011. And most of the dates, my lord, he was remaining present in the school. I have given the, my lord, attendance list at page, my lord, 29 and my lord, 31. So my submission before lordship, my lord, he may obtain BEd either by, my lord, on, my lord, off campus move or my lord, in distance move. And this honorable court already held that, my lord, in Muktaram Decca that, my lord, that, my lord, degree is not valid. So in view of the matter, my lord, since he is not, my lord, valid, my lord, BEd degree, so he may not be the, my lord, regular headmaster. And if he is not, my lord, eligible for regular headmaster, he also may not be, my lord, eligible for, my lord, in charge headmaster. That is my submission to your lordship.
Yes.
Regarding to question of yes.
Heard Mr. Kayum, learned counsel for the petitioner, Mr. U. Sharma, learned standing counsel for the respondent in Secondary Education Department. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 21/8/2025 passed by the Director of Secondary Education Assam, whereby the Director of Secondary Education Assam has allowed the respondent number 4 to hold the charge of in-charge headmaster of Motirsor High School in the district of Dhubri. There is the petition and the documents placed on record, and also there is the order dated 21/8/2025. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents. However, no formal notice is required to be issued to the respondent number 1, 2, and 3, since Mr. Sharma has entered appearance and received notice. But extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 4 be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks. In the meantime, Mr. Sharma shall file his affidavit in opposition.
His case may not be considered for regular since it is.
No, let him file a.
Items for admission, item number 21, order taken.
I don't really see the last order. Wherein I was asked to produce the records are with me. They, for the convenience of the honorable court, I got an official affidavit of record. My lord will kindly see paragraph 6 file. And as per paragraph 6, this may be disposed of as a consenting order. This will do you. Right. Repeated since 2018.
No, that's all right, but Mr. Bhuya,
Yeah.
whether any order has been passed in this regard by the authority, applying the principle of no pay, no work?
Yes, they are. The inquiry was conducted.
Yes,
My lord, suppose notice was issued and he replied to it also.
thereafter you have passed the order.
Yeah. Under this order, 26 November 2025. That's the exception that I have seen.
Affidavit shall last date of file first.
So Iqbal, have you received the order, this order?
As per my instruction, my lord, no focus notice was served upon me, my lord. And there was no order passed, communicated to me.
No, whether this order was served upon you. Order dated 25th of November, 26th of November, 2025.
No, my lord,
Not sir.
not served.
So we have furnish a copy to him
Yes, yes.
so that he
But
can
I am
obtain
not
instruction.
liable for of this case, maybe I can freely suffering with regard to a person not getting salary for the days he has rendered service. So in my affidavit, my lord, can dispose it of, my lord, with the observation that as a constating that he is entitled to the salary and is admitted in the repetition also when he had choice. 16/8/22. 16/8/22, till today, my lord, if he is rendering his service, he is entitled to my lord salary. And with regard to previous salary from 18 to 22, he is not entitled to as per 70E of the FRS server. That's on that basis it can be disposed of.
Disposed of. But
Hmm. Okay. So we'll keep this order on the record,
My lord.
my lord,
this order.
Yes.
my lord,
And it can be, he is entitled to put 16/8/22 till today, my lord, if he is working, my lord. And for that, he is not entitled. Because he has not rendered service.
well, I have resumed service from 16/8/22.
Yes.
From that day, my lord, it can be counted on.
Yes. But before that, it
With
cannot.
interest, my lord, as my lord solid passed the judgment, my lord, with interest.
No, no, that cannot be, my lord. Interest cannot
As
be
in-
that way, that manner, my lord. Because interest for that purpose, when there is a contract, my lord, every person getting into a job, my lord, it's a contract between the employee and the employer. Unless and until there is specific provision in a contract for payment of, my lord, with regard to this interest, it cannot be that way, that manner, my lord. I am not acquainted with this order which passed. And if there is no prayer in the it will be acceptable.
Mr. Bhoya, you see, this is equitable relief. The court may consider it. There are several decisions of the Supreme.
Yes,
Court.
my lord, the decision with regard to contractual matters, my lord, with regard to service matter.
Hmm.
Unless and
has
until,
been
my
clear.
lord, there has been a prayer in the writ petitions
Hmm.
and their opportunity be given to the other side, my lord, it cannot be that way, that way.
Para 18, my lord. That I leave it up to the lordship, my lord, but para 18 specifically, my lord's own judgment is there. my lord. And it has been last year.
With regard to this, my lord, if it is equitable judgment, my lord, 1995 SCC, my lord,
Hmm.
6% per annum, 9% per annum, 10% per annum, whether this court will decide it on this fact because of the fact that.
No, no, that is on the based on the decision of the Supreme Court.
No, that I understood.
Hmm.
But the factual metrics of that particular case, my lord, I am not
Hmm.
acquainted with it right now. I cannot reply to this. But what I am on is this.
Hmm.
With regard to quantum, for damages, always it's open with equitable jurisdiction with regard to, my lord, going to the civil court. Because that quantum has to be decided on the basis of that. That this writ code, my lord, under 226, when there is no prayer at all in the writ petitions, my lord.
You know, Mr. Bhoya, already this court has indicated that it is an equitable relief.
Yes,
And-
equity jurisdiction, there
and-
has to be a prayer.
And considering the facts and circumstances on the record, the court may consider it at the end of the order.
Yes, that's true, my lord, equitable jurisdiction, 26, my.
No,
lord,
you see,
has the
Mr.
Power,
Mr. Bhoya, you see, since when the salary has not been paid?
16/8/22.
22.
Yes,
So you see, today we are in 25.
yeah,
So for 3 years he is without salary.
absolutely, my lord.
Yes, understood that he was not in service for quite some time, so salary was not paid. Then why he was not paid the salary for the period for which he has rendered service since
My lord,
2022?
if your lordship goes to the records, my lord,
Mm.
it appears, even now he is irregular. Even then, I am considering with regard to equity persons, my lord.
No, okay, if he is a irregular, you can take action against him.
Yes, Department of
As
Justice,
per-
that's
as
an
per-
independent right,
Mm.
but what I am on.
Mm.
So far, my lord has all the powers, so what I am, equitable jurisdiction can be invoked on the basis of a principle of law.
Mm,
But that with regard to interest part and all such things,
mm,
it has to be decided on the basis of, my lord, the material, which is not before the court.
mm.
And with regard to this, my lord, it's my lord, a person, a court is passing order, and there has not been implemented, and then I can understand.
no,
But there is
Mr.
no prayer in the repetition
No,
also.
maybe, Mr. Bhoya, you see, you are also admitting that he has not been paid salary since
Yes,
2020.
16/8/22.
But
And
more,
there are communications with regard to this, my lord, that even after that,
Hmm.
he's not regular with regard to, he's not rendering his service. I'm not insisting on that.
Hmm.
I am insisting on that equitable jurisdiction that he should be paid.
Okay, we'll
He should
say.
be paid for which he is entitled to.
Well,
That's all, my.
okay.
And regarding Chopin and all, my lord, everything is there on record, that he has entered into the Chopin, his signature appears. The no Chopin and all such things, my lord, is not.
Okay, we'll see.
Last occasion, my lord, by order dated 24/11/2025, my lord. Para 4, my lord. Para 4, my lord.
What was the order in the writ petition?
My lord.
What was the order in the writ petition?
Order, my lord, your lordship. Page 20, my lord. Start from 20 and operative portion, my lord, your lordship. Page 26. Para 9, my lord. Page 26, para 9. May I read? Lord?
Not necessary.
Upon hearing the learned counsel,
No,
the
Mr. Bora, not necessary.
my lord. Para 10. And 11, my lord. Since the existence of the school is not disputed, the information captured dice code for the year so and so, except for the year 2019, therefore non-availability of the dice code for the year 2019, reason for which cannot be attributed to the petitioner school, cannot be constituted to be a default on the part of the petitioner, disentitle the petitioner school from the benefit of the provincialization order already made by the government. Accordingly, writ petition is allowed. The extent indicated about directing response number 3, Director Elementary Education to pass appropriate order within a period of 30 days from the date of receipt of a certified copy of this order. And this order has been passed, my lord, 27/11/2020, my lord. Near about no more than 5 years, my lord. And review was filed, my lord, after issuing the contempt proceeding. They filed review and review was also dismissed. They willfully and deliberately violation of this order, my lord.
Yes.
Here, my lord, we have filed an appeal, my lord. We have filed an appeal on first of
Where?
It speaks of 21st of January, Lord, it's by this on different program.
Is there any stay?
No, it will be listed. No, not listed here. We have made for early listing of it. As the content is pending, so we have made for early listing, then different as honorable division has picked it in the on 21/1.
I think writ appeal was filed after passing the second, my lord, so forth, my lord. By your lordship, my lord. After issuing first contempt proceeding, they filed review. Review was, my lord, dismissed, and thereafter again second, my lord, contempt proceeding drawn up. Thereafter they filed writ appeal. They filed the writ appeal on the only the save the contempt, my lord. My humble and respectful submission.
So, where is the difficulty in carrying out the direction issued by this court?
Actually, my lord, this dice code was issued initially in the time of another school, my lord. More than SSK, my lord. But dice code was issued name of the petitioner school only in the year 2013. The claim that the petitioner that they have been running the school in the name of.
No, you come to paragraph number 11 of the order passed in the writ petition. Page number 27.
Yes, I think the existence of the school is not disputed in the information captured by dice code. Well, this was communicated by the then block elementary education officer. That is not correct, my lord. Without verifying, without taking any instruction from the SSML, because the SSA is maintained, the dice code is maintained by the SSML. Only these issues, my lord, situation is there as well.
Well, that stand was taken at the time of writ petition. Thereafter, after hearing both parties, this order has been passed. Again, then that stand was taken at a review petition. That was also dismissed. Same my lord. Review was also, that stand was rejected by the Honorable Court, my lord. After hearing,
Here, since we have filed an appeal, let us go this one. Final outcome of the appeal.
Okay, we will list it after 21
January.
January 2026, but we will not dispense with the personal appearance. The director has to remain present on that day also.
my lord.
Heard Mr. N. Bora, learned counsel for the petitioner. Then Mr. P.K. Bora, learned counsel for the contender. Person to order dated 24/11/2025. The contender is present before this court. But Mr. P.K. Bora, learned counsel for the contender, submits that one appeal, being writ appeal number,
Yes.
writ appeal,
Only
which
filing
is
number
the
is
filing
there.
number 15423 of 2025 is filed on 1st of December 2025. Then the same is listed for hearing. No, listed for admission on 21/1/2026.
Good, can you be after that, because on 21st.
Taking
appeal
Robert.
will be listed.
note of the aforementioned facts and the submission of Mr. Bora, the matter is then adjourned to be listed on first week of February. First week of February. Personal appearance of the director is however not dispensed with till then.
Marshal.
39 for motion.
Mr. Gogoi,
Yes.
the petitioner has filed on representation.
Fine.
The same has not yet been disposed of.
Yes, what?
31. Page 31. So far as regarding insertion of the name of the petitioner in the dice code is concerned, there is a prayer made in this representation to the mission director, SSA. My lord, I've got instruction in a similar case, it came up yesterday, how this procedure is followed, how the dice code is asserted, how it is inserted. It is their mayor cases, it is the education department, before whom he will have to apply. Like if it's a LP school, it is a block elementary education officer. They will verify it and they will give the data that whether he is working or not from 2017, whether he is there or not. Then accordingly it follows and it is uploaded finally in the UDA's web portal. Here, that
No,
action has to be carried out.
no, that's all right. If it is not in accordance with the procedure prescribed, you dispose of it.
Yes, that I can, my lordship may, in that case, lordship will allow us, considering the urgency, 7 days time, my lord, will pass an order. But my lord, my advice will be, my lord, he must approach the education department because it will cause delay to him, he will be suffering.
I will file immediately. By
He-
tomorrow also, we will file a fresh
Before the education
representation
department-
before the competent authority, either the education department, DO or BO,
Yes.
wherever it is necessary.
And he
And
knows
within,
that.
within a period of 7 days, they dispose of the matter. Until then,
Yeah.
my application will be kept at.
Whether for the lessons on the part of the petitioner, a recruitment process can be.
No,
Recruitment is
I am
not
not
like-
stalling, I am not stalling the process.
On my application.
That is captain events.
Only on the representation, it will be more appropriate, my lord.
Because otherwise my application will be automatically cancelled.
Hmm.
So by tomorrow, petitioner will file the
Okay,
representation.
till disposal of the
Yes.
representation by the respondent authorities, the petition filed by him shall be kept in abeyance.
No.
My lord,
Till disposal of the representation to be filed by him.
press representation, he will submit before the education
Yes,
department.
yes.
Yes.
So I will file.
Only thing, my lord, that selection process should not be kept in abeyance
No.
because it is.
That direction should be, otherwise it will be issued as that the selection process may be stayed.
They
So
are
that
not,
direction may be there, Roasting.
they are not playing, they want the disposal of the representation.
Let's say by this, let me submit, by this representation, the impugn notice says, if by 3rd of December, if the candidates fail to upload the UDAS report, then his candidature will be automatically cancelled. That's why on last occasion, this honorable court says, you obtain instruction until then, this application filed by the petitioner, the candidature of the, that is kept in abeyance, meaning therefore not to take any decision till you furnish the instruction.
That we have extended, then on last day,
Yes.
it's only been over, Roasting.
That is extended till date.
The last day has already been over, we have extended.
Now,
your-
now my,
On the direction of the honorable court, and the last period has all been over by this time.
No, we are not staying the
Verification-
process.
This verification done as per the direction of Supreme Honorable Supreme Court, Lordship.
আপনি বুঝা নাই বাৰু।
We are not staying the process.
Yes, I'm not,
Process, let the process go on.
That observation, Lordship, can be.
not required because if
No, that is required, Lordship.
it will create complicacy for your betterment, I'm saying. Simply Lordship says, I will file fresh representation before the concerned authority, and the concerned authority will take decision within a period of 7 days. Till then, the application submitted pursuant to advice on 8th of 2020, that should be kept in abeyance. That's all.
January, now in the case, and they have
No.
submitted an representation for.
For 1 week, for 1 week, only for 1 week.
For 1 week, 7 days.
Lordship, ultimately, I am losing the benefit.
Even the fake and.
I don't understand Lordship, why my friend is Lordship objecting. Indirectly, Lordship, I am losing the benefit because my application is yet to be considered till the decision is taken. And the process will be going on.
And my lord, petitioner knew that he was eligible only because of Honorable Supreme Court direction. That although those neos, those who were in service prior to 10/8/17.
No,
and
that's
according-
all right.
They have applied.
Mr.
They should know that. whether-
No, Mr. Sisti,
And
you
now
take a
failure of the
decision
recruitment process,
in
they have
whichever way you like.
submitted.
You take a decision either positively or negatively.
Although the last date has
You
already
do
been
it
over.
in accordance with law. And only till then, the petition filed by the petitioner shall not be dismissed.
Online. That's it. We have to apply for the post through online application. My online application is accepted. The notice, if the candidate
For verification.
who in response of that 8th of January 25, they have to submit the NEOS by the end of 3rd of December 2025. So that is while on last occasion, Lordship, directed to obtain instruction and till then not to take decision on the application filed by
Okay,
the
okay.
petition.
My lord, may I submit, my lord? They will verify the application along with others of the petitioner. And on this particular ground, non-having that, my lord, dice code or his name in the dice code of 2017, it should not be rejected till the representation is disposed.
Yes,
We will proceed, my lord.
that
It
is the,
rejected
that is the
of-
pair made by him.
But
And otherwise, I have submitted on last page the notice dated 27/11/25, whereby the last date was extended till 1st of December. The last date has already been over.
So if tomorrow they found that I am eligible, they have to submit my, accept my application.
All right, next item.
Obliged. Lordship, disposal.
Yes, disposal.
Obliged.
J. Ahmed. None appears for the petition or on call. This is the matter of the review.
item 25.
May it please, Ma'am. This matter pertains to admission into government polytechnic institutes. There are 7 petitioners. They completed ITI from Industrial Training Institutes, Guwahati. Now, for admission into polytechnic, there are 2 modes, my lord. One by giving entrance test, polytechnic admission test, and second mode is that, my lord, those students who complete ITI, they get lateral entry directly to the second year. So these petitioners, they completed ITI, my lord. Lordship, turn to page 21 is the trade certificate of the petitioners.
Now, what is your grievance?
My grievance is that, my lord, I come to that, my lord, just kindly take note of certain, only one document I am placing, my lord, which is in respect of petitioner number 1. He admitted in ITI in the session August 2020 to July 2023.
Page number.
Page number 21. Lordship has got it, my lord. This is in respect of petitioner number 1. So he completed 1 year ITI from Government Industrial Training Institute, Guwahati. Session was, my lord, from August 2022 to July 2023. Similarly, others certificates has been annexed, my lord. Now, Lordship will kindly turn to page number 28 is the type copy, and page number 30. Lordship will take page 30.
Mr. Chakraborty, when did you file this petition?
But this petition was filed on 24/7/2024.
24.
Yes.
For the session?
For that session 24/25.
That is already over.
But it was hard, my lord, it was, judgment was reserved within 2 months. All the pleadings were completed. Unfortunately, my lord, the judgment could not be delivered. It was,
By that time, this petition becomes infructuous, perhaps.
no, but that is there, but this is not due to any fault on the part of the petitioners or all the part of the respondents, my lord, in any way, my lord.
No, now the question is whether there is any seat.
But the next session
to
is coming.
accommodate, the petitioner.
If the next session is coming, if your lordship at all considers, my lord, subject to what subject to outcome.
To give such a direction, you have to amend this petition now.
No, but that order at the initial stage, on the date of issuing notice, an order was made that candidature shall be subject to outcome of the writ petition.
Thereafter, what happened?
Thereafter-
They have been admitted?
No, they had not been admitted, my lord, but judgment was reserved, but judgment could not be delivered. And in the meantime,
Who is appearing for the polytechnics? Mr. Das.
I'll get it.
Yes.
But in that case, in this case, specific specific case of the petitioner was that in the midway, the authority has changed the game of the rule of the game, my lord. And for next session, this petition will not cover this plea. Because for next session already, this notification is already out. Right? The requirement. Minimum eligibility qualification. And that is there from the beginning also.
no matter what happened earlier, my lord, 10 plus 1 year
Let
students.
him complete.
My lord, my lord. I'll just briefly state the facts, my lord, very briefly, my lord. Otherwise,
Let him complete.
lordship.
Rightly, that this petition become instructions as on date, my lord.
Mr. Das, is there any provision for lateral entry?
Vision is there, but the requirement is, my lord, the candidate has to pass 10th plus 2 years ITI course, which the petitioner doesn't qualify for because he has done ITI for 1 year of this.
Is it mentioned in the advertisement?
Yes, madam.
Advertisement is at page number
Page number 30, even.
30.
Yes. 29 is the type copy, my lord, 28. 30, my lord,
Hmm.
dated 10th of January 2024. Lordship has got it. May I read the advertisement?
25th of January 2024, last date.
Yes,
My lord.
25th of January 24. And educational qualification, civil engineering one.
May I read, my lord?
Serial number 1.
One man.
Serial number 1 and 5. Petitioner number 1 to 5 are concerned with serial number 1, and 6 and 7 are serial number 5, my lord.
Where it is provided 2 years ITI course.
Manoj,
It is not provided.
here. This is governed by Manoj, AICTE rules and regulations, madam.
Is it part of the record?
Manoj, AICTE regulations, in part of the record, I have filed along with my affidavit, madam.
Page number?
68 onwards, Manoj, my affidavit.
Respondent number 1 and 2.
Yes, ma'am.
Yes.
Respondent number, filed by the respondent number 4. Annexure 1, page number 74.
Yes.
But this admission into the diploma course in engineering or technology in polytechnic is governed by AICTE, governed by the norms laid down by the AICTE, and as per the annexure, this appendix 1, my lord, the AICTE published by AICTE approval process handbook. And see below, my lord, AICTE approval process handbook with the appendix 1, here the relevant parties, and page 75. 75, my lord, the diploma course table, serial number 5, Roman 5, my lord. All programs lateral entry to second year diploma. Here, the eligibility part, my lord, and you see. First is, my lord, past tense of the exam, that is not relevant for us. The next one is, my lord, or 10 plus 2-year ITI shall be eligible for admission to second year diploma courses in any branches of engineering and technology. So the requirement is, my lord, 10 plus 2 years ITI course. Whereas in this case, the petitioner does not have the qualification. And my lord, this qualification, nothing new, my lord. This qualification is already existing.
What was new then?
Nothing new, my lord. It is the apprehension of the petitioner that the rule has been amended, my lord. Actually, what has happened during the
No, this appendix was issued on which date?
my lord, this is kindly see, my lord, below. AICTE approval process handbook 2023-24. This is the session for 23-24.
When the advertisement was issued?
Advertisement was issued on
25th of January 24.
24.
So yeah, the petitioner does not fulfill the requirement.
Lordship, kindly allow me to place my case for 2 minutes, my lord.
Hmm.
Lordship, in the advertisement, admittedly, my lord, no duration was prescribed in the advertisement. For Lordship,
But AICTE rule is already there.
But that is there, my lord, that the respondent number 3 and 4 have never communicated that this is the requirement. In fact, they have themselves framed the rules. Pratik, kindly take a look at it.
Who framed the rules?
The respondent number 3 and 4, my lord, admission rules.
Hmm.
This is, my lord, this tool is, these rules are still available in their website, my lord.
Hmm.
Admission rules for admission into the 3-year diploma engineering technology courses in the state of Assam, issued by down below, my lord, State Council for Technical Education Assam, Directorate of Technical Education Assam. Next, my lord. For all diploma engineering technology courses except modern office management so and so.
Page number.
Next page, my lord, page number 2. The following rules are framed for the purpose of regulating admission into diploma courses in state polytechnics of Assam. These rules may be called the State Polytechnics of Assam Regulation of Admission into Diploma Courses. They shall come into force on the date of publication and shall be applicable from the academic session 2022-23 to regulate the admission of students into the state polytechnics, my lord. My lord, now lordship will kindly take note. The session in which the petitioners got admitted into ITI was also 2022-23, page 21 of the writ petition, my lord. Now, regarding lateral entry, this provision is made in Rule 14, page number 6.
Yes.
Lateral entry. Hide notification, government letter dated so and so, so and so. That letter I'll place, my lord. The respondent number 1 and 2 have brought up on record. Entry qualification. Industrial Training Institute, ITI passed out students having minimum educational qualification of HSLC passed with the maximum age limit of 17 years and minimum age limit of 17 years and maximum 25 years. For SC, ST, additional 3 years as per existing norms of Polytechnic. B. Provisional selected list will be supplied by the Directorate of Employment and Craftsman Training Assam for admission into bridge courses to be started before the 3rd semester course in Polytechnics. The bridge course will cover the papers of physics, chemistry, and mathematics. The Directorate of Technical Education Assam will admit the students to the Polytechnics of Assam against 10% of intake capacity of each branch from the provisional selected list supplied by the Directorate of Employment and Craftsman Training. Well, these rules, which were framed, my learned friend has appeared for respondent number 3 and 4, but it is their rules, my lord. 2022-23, these rules say that no duration has been provided. My case is that when I got admission, these rules were there into Polytechnic, in ITI. These rules.
That's all right, but are they not supposed to follow the AICT rule?
That is there, my lord. That is there.
Then?
I have checked, my lord. But what fault the petitioners are having, my lord? They have, in fact, lordship, kindly take the affidavit filed by respondent number 1 and 2. It will make the things clear, my lord.
Page number?
Lordship, I am taking page number 80, my lord.
Yes.
And I will also take lordship to the annexers of that affidavit, my lord. This affidavit, as per my understanding, my lord, supports the case of the petitioners. Lordship has got it, my lord, page number 80. Affidavit filed by respondent number 1 and 2.
Yes.
Paragraph number 4. With regard to the statement made in paragraph number 3 of the writ petition, the answering deponent begs to state that as per Directorate of Technical Education letter number so and so dated 12/12/2023, the Directorate of Employment and Craftsman Training Assam had published the advertisement for lateral entry of ITI passed out trainees on 10/1/2024, seeking application from the intending ITI passed out candidates for admission into Government Polytechnic. My lord, that advertisement was issued according to the respondent number 1 and 2 as per instruction of respondent number 3 and 4. But that advertisement nowhere reflects that the duration of ITI course, my lord. That advertisement has been annexed at page number 30. There is no mention. The only 2 years, 10 plus 2-year students are allowed to participate, my lord. Next, my lord, on the basis of the applications received from the candidates, the DECT had prepared a provisional list for the purpose of, on the basis of guidelines issued by DT, Directorate of Technical Education, dated 3/1/2024, and forwarded the same to the Director of Technical Education. The next paragraph is important, my lord. The guidelines issued by Directorate of Technical Education, GTE, no specific course details of the ITI passed trainees was indicated. That is 1-year course or 2-year course. As per records available in the office of the deponent, the Director of Technical Education had issued for counseling for the purpose of entry into Gorf Polytechnic from the ITI passed out candidates. A letter was received on 14/6/2024 from DTE by letter number so-and-so dated 14/6/24 regarding meeting on provisional list submitted by DECT. Accordingly, a meeting was held on 15/6/24 in Conference Hall, Assam, wherein AICTE norms for lateral admission was placed. My lord, after the petitioners appeared in the provisional name appeared, they submitted their counseling process was over. They realized that, my lord, this was the AICTE's prescription that only 10+2 was required. Thereafter, my lord, next page.
No, you say merely because there was omission in the advertisement and also in the affidavit filed by respondent number 1 and 2.
Yes.
But you failed to fulfill the requirement as prescribed.
Lordship,
by the
kindly
AICTE.
turn to page 88. The guidelines has been
Yes.
annexed. Guidelines which were issued
Hmm.
by the respondent number 3 and 4 on the basis of which.
We are in 25 now.
Yes.
The
That is there, my
petition
lord.
was of 24.
And one more aspect, my lord, just 2 placements I will place. My lord, that guidelines, page 88, Lordship may kindly peruse. It was issued on 3rd of January 2024.
Hmm. Maybe, but already the AICTE rule is there.
It is there, my lord, but one, Lordship may kindly see.
No, now you tell me whether in contravention of the rule made by the AICTE,
Yes.
the Director of Technical Education can admit you in the course.
My lord, Lordship, for that, my lord, my answer will be page number 100 of this affidavit, my lord. Page number 100. That reference of that notification is also in the rules. It is a notification dated 12 November 2008. Consequent to AICTE's letter number so-and-so dated 11th September 2003, Government of Assam has decided to adopt the scheme for admission of Industrial Training Institute ITI passed out trainees of Assam in the 3rd semester of polytechnic courses as per the following guidelines. This was not issued by the 3 and 4 by the government, my lord. ITI 1, ITI passed students should have minimum HSLC pass certificate with age limit as per norms of the existing polytechnic and additional age limit of so and so and so and so. Here also, my lord, the prescription is that only 10+1 year. And in the rules, my lord, which I have handed over to your lordship, lordship will kindly take note. Rule 14.
Yes.
At
Yes.
page number 6, lordship will see a reference to this notification only, my lord. My lord, the guidelines of government has the notification. The rules were framed by the authorities, my lord, regarding admission. Nothing was mentioned that 10+2 will be required. And my lord, this notification, in my respectful submission, my lord, was issued in exercise of power conferred under Article 162 of the Constitution of India, which says, my lord, the executive power is coexistent with the legislative power of the state legislature. And if your lordship turns to, my lord, entry 25 of the concurrent list, my lord. The Constitution.
No, that is a different aspect, but.
My lord, Lordship, kindly see, my lord, for vocational training is a entry under the concurrent list, entry 25.
Now you see, whether ignoring the EICT rule, we can direct the respondent authorities to admit you.
But if Lordship considers, because the constitution has given the state government to issue administrative orders in respect
No,
of
no,
vocational institutes.
you first answer my question.
Yes. But
Can
if
you ignore the AICT guidelines?
the
AICT rule?
guidelines, if your Lordship considers harmoniously, my lord, this guideline says that only for permanent residents of Assam, this lateral entry applicable only for those who are having permanent residence certificate of Assam. Only to that extent, my lord, my respectful understanding is that this can be done. In fact, till last year, I have brought on record,
No, even ignoring the AICT rules.
not in ignoring, my lord, in harmonious construction of the rules, my lord, because they have done it, my lord.
No,
They have been doing it.
even if the respondent authorities admit you and you get the degree or diploma, if it was not recognized by the, if it is not recognized by the AICT, then what purpose will be served?
Yeah, that is
Where
there,
you
but
will get employment?
the thing is that has been never communicated at any point of time, my lord. But my understanding, limited understanding, is that irrespective of the AICT guidelines, the state government is also empowered to grant relaxation in certain cases. That is my, and
Is
relaxation,
it provided in the rule?
my lord.
Granting of relaxation is provided in the rule.
In the executive order, my lord, the notification at page 100, state government has exercised that power in exercise of Article 162 of the Constitution.
No, whether in the rule, the power of relaxation is
But
provided.
this is the handbook, my lord. What they are relying is not a rule.
Hmm.
The AICT, what provided that annexers, my lord, page, this is a handbook, AICT approval handbook. Handbooks are also guidelines, my lord. Same guidelines issued by Director of Technical Education, which says no duration is required. Lordship, kindly
Yeah,
see.
what is the status of this rules?
Lordship, this handbook was issued in pursuant to the AICT rule. These are the rules your Lordship will have the rules of 2020. Your Lordship, I have just printed the relevant portion, it's a voluminous book. Your Lordship has the fourth page, page number 29. Rule 2.33.
Yes.
Lateral entry means admission of students into the second year of diploma undergraduate degree course as specified in the approval process handbook. And approval. So the approval process handbook, your Lordship, was issued pursuant to this rule, which was framed by the AICT under section 23 of the Act. So under these rules, your Lordship, in fact, even prior to this 2023-24 academic year, the requirement was always 10 plus 2 years of ITL for lateral entry into diploma. In fact, my learned friend has taken your Lordship through the 2023-24 handbook. This is the 2022-23 handbook, the one prior to that. There also it was always the same way. This is for 2022-23.
Relevant.
11 page is page number 4, your Lordship.
Yes.
We are concerned with 1.1, subheading 5, all programs lateral entry to second year diploma. The eligibility, the second eligibility condition is 10th plus 2 years ITI. And even now, your Lordship, after the new rules have come, even in 2025-26, that has remained the same. This is for 2024-25 to 26-27. Even this here, it is the same.
So this handbook has a statutory force.
It has statutory force.
In view of this clause number 2.33.
Yes.
fact, if your lordship has clause 2.7, rule 2.7, handbook is also defined, your lordship. Rule 2.7, approval process handbook, APH is a handbook published by AICT prescribing norms and procedures for processing of applications submitted for grant of various approvals from time to time. Uh, Handbook which was in force is already on record with my lordship, in your lordship. So prior to that, it was always 10 plus 2 years. The rationale appears, your lordship, is that perhaps for entry into a graduate level course, it appears that they want at least 12 years of undergraduate study. From class 10 to class 12, at least 12 years of study should be there. Perhaps that appears to be the rationale. Because this 2-year ITI course otherwise is in lieu of the higher secondary study that other candidates usually do, your lordship. So perhaps that is the rationale.
But even after passing the SSLC standard also, one can be admitted in the
Yes.
polytechnic.
If somebody has done the higher secondary course, then he will be in the first, your lordship has the rules. Then he will be in the first eligibility criteria. There is one separate criteria for students who have passed the higher secondary course.
10 plus 2.
10 plus 2. So in this case, I made an inquiry with my learned friend. I don't think that the petitioners have done the class. They have not. They have only done their matriculation and then directly done the ITI course. So they will be covered by the second criteria. Okay. Matriculation plus the 2-year ITI course.
So Chakraborty, we are dismissing the petition.
Lordship, my written argument is there, my lord. Lordship, take note of that.
Yes, next item.
Apply.
My lord, I am sorry, my lord. Item 23, the file affidavit.
No, we will not pass any order. We have already passed the order. We have called the matter and nobody turned up.
My lord. So
Sorry.
next week we may fix, my lord.
Sorry. That has already been given.
My lord, here I have received a question, my lord.
Yes.
That the deputy inspector of Duguri has resubmitted the pension as required by the pension department.
Yes. I get more copy to passes. I see. 2611. Yeah, this one over now.
The pension and pension.
Just to pardon your partner, man. Just to pardon your partner. So when the entire process would be complete?
It's up to my lord, the pension department, ma'am.
Pension department. No, but the question is whether the proposal is submitted to the pension department.
Yes, ma'am. We
When?
submitted that 2611. That the second test, my lord.
So madam, you complete the entire process within a period of 6 weeks from today? We are disposing of this petition. And furnish a copy, Mr. Pegu.
Yes.
Just a letter to Mr. Pokon. This page number, second page. Letter dated 26 of 11/2025. Okay.
May I please lodge? Well, this matter is relating to provincialization of service of junior assistant. Well, a notice was issued in the month of April. No affidavit from the government side has been filed. In fact, Lordship, affidavit is required in this case from the department because earlier there was a direction of this honorable court to decide the matter. But that decision has not been complied with. Despite of that, Lordship, they are seeking report, etc. in this way. No decision has been taken in terms of the earlier order.
Mr. Siste, you are appearing in this matter? Where is your affidavit? Where is your affidavit?
Specific notice, the instruction notice, specific because we have not received notice. We'll get it, we'll find it notice. They told you the notice.
I appear for respondent number 8, private respondent, my lord. So today for the first time.
Private respondent number 8.
So I also need to file my
Yes,
affidavit in
sir.
opposition, but sometime needed for me also, my lord.
Yes, sir, Borua.
Yes, sir.
Heard Mr. M. Khan, learned counsel for the petitioner. Mr.
MAI Hussain.
M.A.I. Hussain, learned counsel for the respondent number 8. And Mr. SMT Siste, learned pending counsel for the respondent in
1, 3, and 5.
1, 3, and 5. And Ms. Fukon for respondent number 6, Ms. Borua for respondent number 2. Mr. Siste submits that he may be granted some time to file the affidavit in opposition. Mr. Hussain also submits that he may be granted some time to file affidavit in opposition. Where allowed, recessal list the matter in the first week of January.
Yes.
In the meantime, the respondent authorities and also the private respondent may file their affidavit in opposition.
Yes.
May I please, your lordship? Lordship, this matter will be taken up after some time. Lordship, Mr. T.P. Bora, standing counsel of health department is on lake, lordship. Otherwise, he has received instruction, lordship.
Okay, let him appear.
Yes, lordship. Much obliged, lordship.
Items 43 and 44.
My pleasure. Well, Kansas City order was a Lordship 15/9/2025. The Lordship order was. Alright, yeah. And then are directed to file affidavit Lordship. Thereafter, 2 days has gone Lordship. Regarding selection and appointment.
Again,
Okay, please, I'll-
activity is preparing notice that the process is already over. So we are filing an affidavit notice with the software. We have received it is under preparation notice. Only some registration was required, but the process that is challenging is already over. Anyway, we are filing it by notice by next week or it is already under preparation.
Number of Lordship, next week, that may be fixed. Fix it on next week, Lordship. Okay.
Heard Mr. D. Gogoi, learned counsel for the petitioner. Mr. SMT Siste, learned counsel for the respondent. Secondary Education Department. Mr. Siste submits that he has received the instruction and he will bring on record the same by way of an affidavit. And pays for granting him 1 week time, pair allowed, versus list the matter in the next week. Okay, fix it.
Next week.
Versus list the no.
Well, before vacation, Lordship.
17th December.
Deeply aware.
Items 45.
My lord, my lord, today they have filed, my lord, affidavit today, my lord. So I have received the copy, my lord. Next week, my lord, kindly fix, my lord.
Okay. Heard Mr. Sigdar, learned counsel for the petitioner. Mr. Gogoi for respondent number? 5. 5. Respondent number 5. And for other respondent? Respondent number 1. Your good name, please? P. Rava. And for rest of the respondents? 2. Miss? K. Bortozari, learned counsel, appearing on behalf of Mr. A. Somo, learned standing counsel for the respondent number 2. Who is for respondent number 3? You, Mr. Tobilda for respondent number 3 and 4. 3 and 4. Mr. Sigdar submits that respondent number 5 is 5. The affidavit in opposition today morning when he has received a copy, and he will file his response to the aforementioned affidavit in opposition and replies for listing the matter in the next week. We are allowed, this is list the matter on 19 December.
Hello.
Yes.
My lord, some positive development is there, my lord. My lord, may I place my instruction, my lord? My lord, in fact, the supplementary demand for the entire amount has been, my lord, passed, already passed, 82 crores. And now, my lord, by day 1 or 2, my lord, we'll have the assent of the governor. And in thereafter, my lord, they will submit a proposal and it will be released. So I pray lordship will, by this month, my lord, I have talked with the authorities, the entire amount will be released. Because it has been passed by the assembly.
Okay.
So my humble submission, let it be on 16, my lord.
মানে already assembly face হয়েছে already assembly ফেরি গইল 5 16 updated
Let it be on 16, my lord. I will place the updated one. It's in a positive note, I am saying I have talked with the authorities, entire amount. It is part of
Now, what remains to be done? The governor will give assent.
Yes, governor will give the assent. And thereafter, higher education will give a proposal immediately because the money is there now. Then it will be sanctioned by the finance and it will be finally, my lord.
Lord,
So that part-
let
no, let it be
everything be
there.
completed by the end of this year.
No, they have said, my lord, before 31st December, it will be released because it has been passed by the earlier, my lord, there are some difficulties.
Lordship will record this statement.
Yes,
Lord.
yes. So let it be on 16, I am making a submission.
ठीक है,
If you are
ठीक है।
16, I will place the updated again before the vacation. Or 18, my lord.
Mr. Ken Sodha, learned senior counsel assisted by Mr. D.Z. Das, learned counsel for
Lordship will record, my lord, whatever is there in my instruction.
Mr. B. Gogoi, learned standing counsel for the finance department, and Mr. K. Gogoi for respondent number 1. Mr. Tobilda for respondent number 3. 4. Mr. Goswami for respondent number 5. Respondent number 5. 6. Mr. Goswami, learned standing counsel for the finance department has produced one letter dated 1st of December 2025. And on the basis of the said letter, he submits that the respondent authorities will pay the entire amount by the end of this month.
Yes.
By the end of this month, and that supplementary demand has already been approved by the assembly.
Yes.
And now the proposal will be placed before the governor for assent, honorable governor for assent. And thereafter, the department will place the proposal before the finance department, and the finance department will sanction the same immediately. And by the end of this month, entire amount will be paid to the petitioners. And Mr. Gogoi press for listing the matter on 16th of December.
18, my lord, I will say.
18th, I will not be there, let it be 16, my lord.
Okay, on that day, Mr. Gogoi shall produce the updated instruction before this court. The letter produced before the court today shall be marked as an excerpt A and be tagged with the report.
Deeply obliged.
My fellow lordship, last occasion your lordship directed, my lord, directed the instruction that whether the order has been complied or not. But order has not been complied, my lord. It is a case of 2016 matter contempt. Notice was issued, but thereafter the respondent filed review. So because of that review, that my lord, this matter, my lord, was not taken into
What is the
consideration.
outcome of the review?
Well, review has been dismissed, my lord, their review has been dismissed. So since notice has been issued and it is there, we have taken steps in 2017. May I be permitted to take fresh steps upon respondent's contempt, my lord?
Okay. Heard Mr. Hawk, learned counsel for the petitioner. Mr. Hawk on instruction submits that the order dated 12/5/2015 passed in WPC number 3165 of 2010 has not yet been complied with. And he also submits that the contemnors have preferred on review petition, being review petition number 78 of 2016, but the same has also been dismissed. And though he has taken step upon the contemnors in the year 2017, he submits that he may be permitted to take fresh step upon the contemnor again. Where is accordingly allowed, list the matter after 4 weeks, then after 4 weeks. The petitioner shall take step upon the contemnors within a week from today by registered post with AD and also by usual process. And additionally, dusty service is also permitted. And after effecting service upon the respondent contemnor by dusty mode, the petitioner shall file one affidavit before this court.
Obliged.
This after 4 weeks. It's a dead 2016 matter.
Obliged.
I don't, 31.
On the last occasion, the respondent was directed to take instruction on the matter.
May it please your lordship. Lordship, instruction has been received, my lord, and it says that, my lord, the petitioners are covered under the new pension scheme, my lord. They have been working from 14 July 22 and they have been receiving their salary, my lord. And moreover, my lord, the order for which this contempt has been filed, my lord, this is an interim order. In the main, the writ petition has already been dismissed by the coordinate bench of this honorable court, my lord. And against the dismissal order, my lord, a writ appeal has been preferred by some of the teachers, my lord, some of the petitioners. So, my lord, since the writ appeal has been pending for adjudication, my lord, may keep this matter after 6 weeks, my lord. In that writ appeal, my lord, notices were issued. And
When the next date is fixed.
there is no fixed date, my lord. Writ appeal writ appeal number 370 of 2025, my lord. It was listed before the honorable division bench and notices were issued and it was fixed after 6 weeks. So, my lord, if any order will be passed in the writ appeal, my lord, they might cover this contempt. They might have a case, my lord.
Otherwise, also, this is not in violation of an interim order. This order was in the nature of a final order. There was an order to pay 1 month salary. It was admitted that their service was regularized with effect from 2015. And the government also lordship admitted that due to financial constraint, they could not be paid the amount. Thereafter, neither they have filed any affidavit nor have taken any action to release the salary. Lordship. In the order, there is nowhere stated that it is as an interim measure, this order was passed. It is in the nature of final order. In page 28, Lordship.
Madam, you say if the writ petition was finally disposed of by passing a final order,
Yes.
then this interim order would have been merged with the final order.
Lordship, in the repetition, Lordship, it was nowhere stated that this any order passed earlier shall merge with the final order, first of all this. And then
No, maybe, but
it cannot be presumed, Lordship, because it is not an competition is on a separate proceeding, Lordship, regarding non-compliance of an honorable court's order. It is not on the merit of the case.
no,
Lordship.
no, that's all right, but we have to see whether that order is existed or not.
Lordship, when this order was passed, Lordship, this order was valid because the proceeding was pending.
No,
and
that was valid at that point of time, that is all right, but subsequently the main repetition has been dismissed.
Yes, madam.
But Lordship, dismissal of the writ petition does not automatically make this contempt petition infrastructure, Lordship.
Maybe, but the interim order would always merge with the final order.
There is no such order, Lordship. It
No,
simply says that the contempt
there is-
petition will.
There is no requirement of passing such order, but it is always merged with the final order.
Lordship, yes, Lordship. On merit, Lordship, this repetition was dismissed, but this contempt petition is filed for non-compliance of the honorable court's order, and when it was enforceable when this order was passed, and it was maintainable at that time, Lordship. And they have not complied
But,
it, and due to non-compliance,
Subsequent events,
Lordship,
subsequent events,
subsequent.
so do we ignore the subsequent events?
Lordship, further subsequent dismissal will not, Lordship, release them from their liability to comply the order, Lordship. And they may file,
There
they
is
may,
one decision of the Supreme Court that the interim order always merges with the final order. Find out that decision and flash before this court on next day.
yes, Lordship, there is also a decision of the honorable court that it was regarding the jurisdiction, Lordship. Here it has stated that, Lordship. The said decision does not, regarding the, Lordship, in this case, Lordship, jurisdiction issue was later on considered, Lordship. The court has no jurisdiction, but interim order, whether it will be, Lordship, respondent is liable to comply it or not. Here the honorable court said that the said decision does not render them either non-est or without jurisdiction. Lordship, when this order was passed and
No,
it was
first,
enforceable,
Madam Bora, you say first we have to ascertain whether that interim order as on that exists or not.
it was in the nature of final order, Lordship. Lordship, may kindly see the page 28, fourth para, Lordship.
May I, Lordship? It was directed to the Commissioner and Secretary, Government of Assam Education Department, as well as the Commissioner and Secretary to the Government of Assam Finance Department, my lord, for implementing that order. So, my lord, they will be knowing, my lord, about this. Whether any current salary has been released, my lord, at that time, my lord, because directions were issued to them, my lord.
Lordship, they may file their affidavit, Lordship, we will file reply. And from 2017, they have not filed any affidavit. This is also a
Okay, you file your affidavit.
disobedience of honorable court's order.
Lordship says read appeal is pending, my lord.
Okay.
Maybe, Lordship, this is a separate
And,
proceeding.
In the meantime, you file the reply,
Lordship,
file the affidavit.
Affidavit.
Lordship.
Or means Devi Learned Counsel for the Pitching. And Ms. Bora for the respondent container number. Five BTC, Secretary BTC,
Lordship.
5 and 6.
Finance is also there, my lord. And
4, 5 and 6. 4, 5 and 6. And finance, who is appearing for finance department?
Earlier, it was B. Gogoi was appearing, Lordship, in the petition.
Is spoken for respondent number 1.
And his undertaking was, is recorded in the order, Lordship. at page 27. Page
Ms.
27.
Bora, learned counsel for the contempt order number 4, 5, and 6 submits that the order for non-compliance of which this contempt proceeding is initiated is an interim order passed in the WPC number 5861 of 2017. And after final hearing, the aforementioned writ petition has been dismissed by a coordinate bench of this court. And against such dismissal order, some of the petitioners have preferred one writ petition or the writ appeal being writ appeal number
Readable number 370 of 2025.
370 of 2025. And the same is yet to be disposed of. And on such counts, he applies for listing the matter after 6 weeks. Pair allowed. Recessal is the matter after 6 weeks. In the meantime, Ms. Bora shall file the affidavit, if so advised. After 6 weeks.
Oh.
Item 33.
But I'll bring some more time, in fact, we have prepared the review and send it for vetting, so why next week we can find fix the matter immediately after vacation, winter vacation.
They should file it early, my lord. Twice they have taken time, my lord, saying that it's going to file shortly.
First time, second time I'm seeking time. His secretary is out of station.
Heard Mr. M. Dotto, learned counsel for the petitioner. And also heard Mr. Khatonir, learned counsel for the contender. Mr. Khatonir submits that he will be filing. No, submits that review has already been filed or not filed.
I have sent it for vetting.
That review petition has already been prepared and sent it for vetting. And a press for listing the matter after vacation.
After vacation.
They are allowed to list the matter on probably first week of January.
On 7.
But deeply obliged.
Item 34.
Lordship, I have instructions to appear in this matter, my lord. Do you have file or wakalanama today, my lord? For the contempt.
Contempt, sole contempt.
Heard Mr.
R. Sharma.
R. Sharma, learned counsel for the petitioner, and also heard Ms. Bora, learned counsel for the contender. Ms. Bora submits that she has instruction to appear before this court, and she has filed wakalatnama today. Today. Accordingly, it is provided that recessal is the matter the next week.
Lordship, after 4 weeks, my lord, will be.
Yes. Why 4 weeks?
Before vacation and the lordship.
Okay. 16. Prayer allowed recessal is the matter 16.
70.
70. 7.
Lordship.
35.
In the meantime, Ms. Bora shall obtain necessary instruction.
Your lordship, here, your lordship, we need to file our affidavit. The instruction received on 29/11/2025. So some 2 weeks time may be granted to us, your lordship, to file our affidavit.
My lord, it is sanction amount, my lord. Sanction amount, my lord,
No, why affidavit is necessary?
The re-sanction order from government is still awaited. Your Lordship, as.
Now, why affidavit is necessary?
Then, Your Lordship, it was not visible, Your Lordship, to read it, Your Lordship.
Hmm?
It was not visible to read it, Your Lordship.
You obtain a legible copy?
Yes, Your Lordship. Then any date, Your Lordship, after 1 week. Next week, Your Lordship.
No, in the meantime, you ask the contemnor to make a payment of the amount.
Yes, my lord.
Why affidavit is necessary? Amount is already
Earlier,
sanctioned.
director also issued a letter, my lord, on 1st November 2025, my lord, which is also on record, my lord, whereby, my lord, already earlier, my lord, this amount was sanctioned, but during the lifetime of my husband, my lord, it was not, my lord, withdrawn, and therefore, my lord,
Lordship, the directory has proceeded the file afresh and resubmitted the proposal to the government for resanctioning of the medical reimbursement bill. And thereafter, Your Lordship, they had sent it, and the resanction order from the government is awaited. And on receipt of the resanction order, necessary instruction shall be communicated to the inspector of school and the DTO.
Government means,
For concerned for royal disbursement, Your Lordship.
government means,
Government instruction is awaited, Your Lordship. Already file has been, Your Lordship, made, and that Your Lordship placed before the government.
now where it is pending. No, where the file is pending at present.
Government, Your Lordship.
Government means with whom?
my lord, as per letter dated, my lord, 1/11/2025, my lord, which is, my lord, as annexure A, my lord, by the honorable court, my lord. By this, my lord, my lord, secretary,
Principal Secretary. State of Assam.
my lord, the
representative.
director of education, my lord, wrote letter to the secretary to the Government of Assam, my lord. So, my lord, further,
I need to obtain instruction, Your Lordship, by Principal Secretary, Your Lordship.
already, earlier order, my lord, your lordship was directed to obtain instruction, my lord, updated instruction. So, my lord, again,
20
instruction, my lord.
Received this instruction, Your Lordship. Apart from that, Your Lordship, nothing has been mentioned by Secretary. So, Principal Secretary, Your Lordship. So, Your Lordship, date may be given, Your Lordship, as Your Lordship, this is a fresh instruction which I received. Principal Secretary. Principal Secretary is no longer. Now, Your Lordship, State of Assam represented by Secretary, not Principal Secretary. So Principal is no longer, Your Lordship. They have to, Your Lordship, make the Secretary party. Secretary or Principal nine.
What is the status of secretary? That should be, my lord, known to the court, my lord. And my lord,
Mr. Hussain, learned counsel for the petitioner. Ms. Peters, learned counsel for the contender number. UFO 1 and 2, 1, 2 and 3. And Madam, UFO 1, 2 and 3. And UFO?
Appearing on behalf of SK for respondent number 5.
M. Does learned counsel appearing on behalf of Mr. S. Learned counsel for the contender number 5. And you?
Appearing on behalf of Mr. D.P. Bora, you host Lordship, for Health Department Lordship.
Mr. D.P. Bora for Health Department.
The vacation of this more fresh instruction.
Respondent number 7. Contender number 7.
Yes, it is
Ekon বেলেগ হয় Ekon fresh হয়
already sanctioned amount.
Ms. Das, learned counsel for the contender number so and so submits that same may be granted further time to obtain up-to-date instruction. Where allowed recessal is the matter on Friday.
My lord.
Friday, you obtain verbal instruction and apprise this court
Yes.
about the status of the file.
Secretary.
Yes, yes.
কিমান আছিলে মোৰ?
Obliged, my lord.
None appears for the petitioner on call. However, Ms. Sutia for respondent number,
Elementary education.
respondent in elementary education department, and Mr. Bora for SSA, respondent number 6 present. List the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
Pleasure, Lord. Lordship, he is still on lake, Mr. Deputy Governor. Otherwise, Lordship, last speaker who was directed to produce original records, Lordship. Records is here, Lordship, is Lordship may pay once.
So what is the direction of this court?
Lordship, our contention is that, my lord, they came to the conclusion that I have 18% disability, my lord. And our contention is no physical, no any examination, my lord, nothing was done. How can they conclude that I am the 18% disability, my lord? Otherwise, my disability certificate is permanent disability certificate. It cannot be changed, my lord. Kindly see, valid up to permanent, my lord, and this certificate was issued, my lord, as per, my lord, the right of persons with disabilities rule 2017, my lord, and rule says, my lord, rule 18, my lord, 18(3), 18 sub-rule 3(1), my lord, the medical authority shall, after due examination, issue a permanent certificate of disability in case where there are no changes of variation of disability over time in the degree of disability, my lord. So, my lord, my disability certificate is under this rule, my lord, and this certificate cannot be changed, my lord, and the impugned, my lord, order, kindly see, my lord, page 28, my lord, they rejected my admission, my lord, as per notification 13/5/2019, my lord, and 13/5, this notification also clear, my lord, lord, regarding the how can they examine and how can they, my lord,
So whether you have appeared before the board,
yes, my lord,
you have appeared,
I have appeared, my lord.
then
Then, my lord, this impugned office order was issued, my lord, annexure 8, my lord, page 58, my lord.
so on what basis you were submitting that you have not been examined by the board?
We appeared, my lord, no physical examination was, no X-ray was done, my lord. Nothing was done, my lord. That's why, my lord, last occasion, this honorable court directed to produce the record, my lord, whether I was examined or not, my lord. If I examined, how they can examine and how they can, they came to the conclusion that I have 18% disability, my lord. Nothing was done, my lord. Without any examination, my lord, how can they came to the conclusion that I have 18%, my lord? In the morning, I was appeared, my lord. In the evening, this impugned order was issued, my lord. No X-ray, nothing was done, my lord.
And rules, my lord, clearly says that, my lord, my disability certificate cannot be changed, my lord. This is permanent disability certificate, my lord. If there is a, my lord, chances of changes, my lord, the authority can issue the certificate with disability, including the period of validity, my lord.
No,
There is no
here,
period of validity, my lord.
Here, they have conducted investigation.
Yes, my lord.
And on the basis of investigation, they have assessed your disability at 18%.
Yes, my lord. What is the basis, my lord, of investigation?
They have better
If any
file an affidavit.
X-ray was done or not?
File an affidavit.
Short date may be given, my lord. This is matter of admission, my lord. Earlier, this honorable court also granted 2 days time to file affidavit, my lord.
Heard, Mr.
HL Ashkar, my lord.
Learned counsel for the petitioner and Mr.
You first.
You both learned counsel appearing on behalf of Mr. D.P. Bora, learned counsel, standing counsel for the respondent of purpose. Today, Mr. Ghosh has produced the record of examination of the petitioner by the board pursuant to the order dated 24/11/2025. The learned counsel, standing counsel for the respondent authorities are directed to bring on record the documents produced before the court today by way of an affidavit. Process shall list the matter on next Wednesday.
Record may be kept on file, my lord. This record may be
No,
kept on
and,
file.
we have to return this
Yes.
original document
Okay.
so that they can file their affidavit. The document, original document produced before the court today shall be returned to the council for the respondent authorities so that the affidavit may be filed within time.
Most of like.